Content original community. As
come before us?
It has not yet come before us.
No.
It's been,
The question is this, do we have the roster?
my lords are having.
It is education.
Yes, no, my lord, it's a service matter where some warning has been given. KCT matter,
From say, appeal, writ appeal. Okay.
21, 2:30 any, next week at any time. Very, I'll not take more than,
Be 2:30, we'll list it. Please be
at
ready.
your my lord's convenience in this ensuing week.
Yes.
Old matter 21, because I am due to retire.
I permitted, my lord. RFA of the year 2011, it was disposed of. I filed an application seeking amendment of decree. Any date your lordship pleases.
Order correction ಇದೆ ಮೇಡಮ್ ನಿಮ್ಮ ಮುಂದೆ ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಇದೆ ಮೇಡಮ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಇದೆ ಮೇಡಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿತ್ತು ನಿಮ್ಮ ಮುಂದೆ ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
Notification of the. Which bench? Not which bench.
Is it the bench?
Nothing.
Please,
Nothing.
look, and if it is not, please inform.
This is an appeal of the year 2015 of a person, lady, who is around about 85 years old and a lot of medical issues are there. It was admitted in 2015. May it be listed for final hearing during the course of the week.
Not
She is
during
an
the course of-
85-year-old woman.
Not in the course of the week, but please include,
Warning list.
yes.
Any mentioning? List 1, page 1, number 1 and 2.
Lord, serial number 1 and 2, in fact, Lord, are likely to be settled. We're trying for a settlement.
That's so.
3 weeks, my lords, 3 weeks, 3 weeks.
Yes, yes. We'll formally admit the appeals
Yes,
and
3 weeks.
give you a date. In the meanwhile, please tell us if it is
We shall,
being settled.
yes,
Otherwise, please be ready.
yes. my lords.
For final.
Admit. is fine.
More
1 and 2 both.
date go for the date.
10th February,
10th, much of this,
Would it be on 11th? Instead of 10th, 11th.
11th.
Grateful.
much of.
Page 2, till number 3.
Yes. Yes.
Being led by a senior. Coming the first week of February.
It's already a say can be admitted and
For the respondent number 1 in this case. my
there's
lord, the
already a
copies-
stay, can be admitted and listed.
The copies is not being served on us. ma'am.
Copy of what? Copy of what?
Copy of
I'm-
petition, my lord.
I am appearing in one of the restaurant, but the interim order does not survive because pursuant to the order of the current seat has been acted up.
Let's do something. Let's just admit this and list it for hearing on a date that both of you
But
agree on.
that it is rendered infructuous, stay doesn't survive. They should not take advantage that matter is admitted, so they are preventing us from proceeding with the construction. That's why I'm,
First week of February.
6th.
but your lordship may kindly clarify, because they are,
True. Yes.
stay doesn't survive, your lordship may kindly.
Six two.
Page 3, 4 to 7.
That's serial number 6, I'm for the appellant in this case. We go to produce a notification with regard to the line. The party requires a week, 10 days time for that. Notification.
10 days has been happening for 5 times at
Malad,
least before today.
What
More
has
than
happened
2
is,
months they have taken
what
to
has
produce the
happened is,
notification.
a new person has come into the place and he
It will
requires
not change the
notification.
notification also.
Notification is of a date of 2011 and 12.
Absolutely. If the notification is not there, your
I
appeal
understand.
fails.
I
That is the end
understand.
of it.
I understand, Manoj. We have communicated that to the party. They have requested for a week to 10 days time. Next week itself, I request. Manoj.
The whole process has been done in a very callous manner, madam.
No, Manoj.
Is there an interim order?
Interim order is there, that may be
If,
vacated.
if you don't have the notification on the next date of,
Very well.
the interim order will stand vacated.
Very well.
The learned
Next week it
counsel,
may,
the learned counsel for the appellant, writ appeal number 1203. Learned counsel for the appellant seeks further time to produce the notification on which reliance is placed by them. The learned counsel for the respondent submits that there is an interim order in operation and that time has been repeatedly sought to produce the notification. List after 3 weeks. Give a date. However, it is made clear that in case the notification is not produced and the matter is not argued on the next date of posting, the interim order granted shall stand vacated.
Obliged.
11-2.
11. Lord, may I request either 10th or 12th, my lord, 11th?
10th.
10th, obliged.
Page 5, serial number 8 and 9.
Serial number 9, appearing for appellant, my lordship. In this matter, senior is not.
Number 9.
Yes, my lordship.
For the respondent.
Just a moment, please. Chit transaction.
Yes, my lordship.
Preliminary hearing. 2021 writ appeal.
That's
See,
a
in-
due of more than 4.5 crores, minutes. Of course, if they have any inconvenience, your lordship may have it next week, minutes, a very short date.
Date may be, senior is, council is not in station, my lordship. Then next week, I will argue the matter, my lordship. Kindly have it.
Monday.
Yes, my lordship.
27th.
Please be ready on that day.
Yes, my lordship.
The learned counsel for the appellant seeks a short accommodation on the ground that the senior counsel has some personal inconvenience today. List on Monday.
Yes, my
for
lordship.
preliminary hearing. Please be ready on that.
Much obliged.
Please.
Page 6, serial number 10. Page 7, 11-14. Page 8.
13, my lord. 13. I'm appearing for the respondent number BCD, 1 BCD.
Lords, it
Please
has come up
respond.
for consideration of LR application.
They have not served the copy and us to file the objections.
This is ordered.
Please, notice servagi.
Can be allowed.
Please be here. Yes.
Page 8, 15-20. Page 10, 21 and 22. Page 11, 23-25. Page 12, 26-28.
Milords, serial number 26, Milords. In this case, we have filed our memo of retirement, Milords, today morning. We have the appellant has taken back the file, Milords. Yes, Milords.
You're appearing for?
Appellant, Milords, in this case. We have filed our memo for retirement also, Milords, today morning.
Yes. Week's time to comply with the office objections. List after a week.
Much obliged.
Page 30, 29 and 30. Page 14, 31 and 32. Page 15, 33-35. Page 16, serial number 36-38.
Serial number 37, my lord. I appear for the appellant. I have been led by a senior counsel. It's for the reply, my lord. I have, short accommodation, my lord.
Partnered matter.
Please, my lord. Thursday, my lord. Yes, today is in Delhi then. Please, my lord, I will inform.
23rd.
Yes.
23rd. Much obliged.
Page 17, 39-43.
Serial number 39, seeking short adjournment.
Sorry.
39,
Yes.
next week it may be taken.
It's coming up failure. Who appears on the other side? Have you informed the other side? Please inform. Please inform and inform the court officer, after which it can be adjourned. Yes.
Page 18, 43. Page 19, 44 and 45.
And for the petitioner,
File hearing,
yes, my lord, I seek,
Institute of Management,
yes, my lord.
19 matter.
Yes, my lord, some inconvenience. Senior counsel is engaged today, my lord.
What is the matter about?
My lord, it's about, there has been no determination of fee insofar as the petitioner institution is concerned. There is an allegation that, my lord, I had collected an excess fee and I was asked to refund the so-called excess fee that is collected. In fact, my lord, what I have collected is only the tuition fee plus the college fees.
You have an interim stay?
Yes, my lord.
Yes, listed on some near date for preliminary hearing. Yes,
In any day next week,
27th.
yes, please be ready on that day, please. don't
27th. Yes,
Seek adjournment on that.
yes, yes.
Page 21, seal number 46. Page 22, seal number 47. Page 23, 48 to 49. List 2. Seal number 1, Vincent page.
The respondent statement.
Yes.
Sorry.
We have not
Yes.
received the copy of the report that they have filed.
Yes, sir. Maybe.
It's mailed.
I have not received.
What is the report?
Lord,
There's no copy. There is a copy.
Just. Sir.
Petitioners Council, do you have any information from your daughter?
No, your lordship, I already forwarded the report to the petitioner. I didn't get any reply from.
Ask her to file an affidavit. She also, because there appears to be a criminal case registered, there appears to be allegations against her. And now, if there is absolutely no information from her, ask the petitioner to file an affidavit to
Yes,
that
your
effect
lordship.
also. Because, yes, from what date she has not been contacted, and she must swear to an affidavit that she knows nothing about the daughter. You as well.
Yes, Your Honor. The respondent
four
is
as
present
well.
before this honorable court also, Your Honor.
Huh.
Pertaining to the same,
Huh.
we have already come, we have fully
But you
assisted.
had submitted the complaint in the first place.
I apologize, Your Honor.
You had submitted the complaint in the first
Yes,
place
Your Honor.
before the police.
Yes, Your Honor.
Hmm.
It's based on my FIR, on my complaint that the investigation has taken place. Subsequently, they have come before this honorable court, Your Honor,
Even
filing
so,
a
we
habeas
don't
corpus.
have any pleadings from you on record. Please file an affidavit to the
Certainly.
effect that whether you have heard anything from her, do you
Cer-
have any useful information?
Certainly.
We have reason to suspect now from July, she's not heard of.
Yes, Your Honor.
And in the circumstances, we'd also like to know what happened to her. Because
Certain-
it is possible either that she's just staying away to escape the consequences. It is also possible that something has
Untoward incident.
occurred, something untoward
Certainly.
has occurred. We do, heavens forbid. So that please ask him to file an affidavit stating as to when he was, he had any contact in
Certainly.
whatever nature from her.
Your
And
Honor,
whether he has any suspicions, whether he has any information with regard to where she might be.
certainly, Your Honor. Your Honor, my application which I filed before this honorable court is detailed, Your Honor, to that extent.
Hmm.
That I have stated that, she left my house
Hmm.
on 22/7/2024.
Hmm.
And subsequently, there has been some certain allegations pertaining to her having a relationship with some other people also. And that has also been informed.
Hmm.
that relation, it appears only to borrow money. She intentionally would leave a telephone back, but would carry her baggage and leave the house, which is
And the
captured,
mobile phone is left back at home.
intentionally left it. And she
Because
carried,
otherwise it's possible to trace her.
Yes, Your
Yes.
Honor.
baggage is taken.
Know whether she has any other connections, so many things that
I-
come to mind. If as a matter of fact, it is an intentional thing as such,
Certainly, Your Honor. I'll file an affidavit to that extent, certainly.
let them place an affidavit on record.
Yes.
We'll- You as well. If there is any information, please divulge it so that they can make a proper inquiry. There is a human life at stake. which is the only reason we are saying this. Otherwise, technically, we could say it is only a case of man missing. It is not habeas corpus. There is no allegation even of illegal detention. But still, yes, Your Lordship. We've perused the status report placed on record by the learned SPP, the learned counsel for the petitioner, as well as learned counsel appearing for the fourth respondent, seek a short accommodation to place their respective pleadings on record. List after 2 weeks.
Yes, sir, 2 weeks.
Meanwhile, please place an affidavit on record. Do you have any information? Do you have any suspicion?
Certainly,
So let it be, come on record.
certainly.
Fifth January, February. List one. Number 1, 2, and 3 adjourned. So number 4,
Serial number
government
4,
advocate.
For the state, my lord.
State of Karnataka,
This, my lord.
para 6 of the judgment.
Yes, my lord.
Admit that it is without notice.
So,
Assistant Commissioner's order is under challenge.
yes, my lord.
The learned single judge says there is an alternate remedy,
Please, my lord.
but this is the second round of litigation. The first round, it is 2 acres, 25 guntas of
Yes, sir.
Gomal land.
Yes, my lord. This,
Regularization order on 6/9/2007.
yes, my lord.
The petition
Allowed.
was filed. The grant was made. Cancellation by AC,
Please, my lord.
reversed by the by the appellate tribunal.
My lord.
And that holds good. On 11/11/2016, AC again passes the order.
Please, my lord.
Learned single judge records that it is admitted that order 11/11/2016 is without notice. What
Please.
is wrong with that?
He has taken the writ petition has been filed by the respondent, my lord. He is landless. The governmental land can be granted only to the landless.
Still. Whether he's landed, landless, all
Ye-
this.
ye-
how we
Yes,
decide?
he has filed the petition before the honorable judge with a false ground contention, my lord. The order is,
How do you decide all this without even putting him on notice, without hearing? This
It-
is the short ground on which the learned single judge has found that the order is wrong. Paragraph 6.
yes, my lord. Alternative remedy.
Absolutely nothing. Alternate remedy is not a defense when you do things like this. Violation of principles of natural justice. Is alternate remedy a defense then?
It's wrong, but it's a
He
good.
can pass orders, he can
Orders-
avail the alternate remedy.
The land is Komala, which is of reserved for the village, benefit of the villages, my lord.
The very
is the ground.
same AC has regularized the occupation.
Occupation, my lord.
2007,
Yes, my lord.
correct?
Yes, my lord.
Taken up before the appellate tribunal and reversed.
Reverse. Later on, so remanded to the AC,
The cancellation was reversed by the appellate
appellate
tribunal.
tribunal.
That remains.
Yes, my lord.
Nothing is done. Now the AC again does the same thing, but without notice. Can it be done? So all the learned civil judges said, absolutely nothing wrong. Sir. Please tell us if there is anything we
I'll call for the records and let me,
to do what?
from AC, original records.
What? Please see paragraph 6
Yes, my lord. The
of the judgment.
page number 20.
Clear admission. Learned additional government advocate admits that the impugned order is passed without noticing. It can be remitted back to the authorities. He would further submit that the petitioner has an alternate remedy. The learned single judge says alternate remedy is not a bar when you have not heard, quashes it, and does not say anything on the merits of the matter. If it is permissible under law,
Yes, ma'am.
if it is permissible under law at this distance of time, do whatever you can. Nothing stands in the way
Please, ma'am.
with proper notice.
Please, ma'am.
After hearing him, after considering his contentions.
Please, ma'am.
heard the learned additional government advocate appearing for the appellant and the learned counsel appearing for the respondent. We noticed that the learned single judge in the judgment under appeal had specifically recorded the admission that the impugned or that the order impugned before him was one passed without notice to the petitioner, and that the matter can be remitted back to the authorities. The ground raised by the government advocate that the writ petitioner has an alternate remedy by way of appeal has also been considered by the learned single judge. However, the learned single judge found that the order issued by the Assistant Commissioner on 11/11/2016 was without notice to the writ petitioner, and that on that short ground, the writ petitioner would succeed in the writ petition. Having considered the contentions advanced, we noticed that the occupation by the respondent herein had been regularized in an earlier round by the Assistant Commissioner on 6/9/2007. And Sagwali Chit had also been issued pursuant to a writ petition and a contempt of court case filed by the respondent here. The same was, the grant was later reversed by the Assistant Commissioner, which was taken in appeal, and the appeal was allowed in favor of the respondent. The said order remains undisturbed. It is while so that the Assistant Commissioner has issued the order dated 11/11/2016, that too without any notice having been issued to the petitioner as admitted in the writ petition, during the consideration of the writ petition. In the above facts and circumstances, we are of the opinion that the judgment of the learned single judge is perfectly legal and valid and does not require any interference in exercise of the intra-court appellate power of this court. The appeal fails, same is accordingly dismissed.
Five, Prakash Shetty, yes.
Your Lordship, may kindly pass it over, my lord. I will come and argue it.
Pass
Kindly
over.
pass over, my lords.
Pass over.
Six, Adjournment. 7, M. Narayan Bhatt.
Here number 7, my lord.
Yes.
First matter, I have served copy on my learned friend. And I filed acknowledgement on,
Copy served.
copy served, acknowledgement on 26th September 2024. my lord.
Yes.
Serial number.
This matter, my lord,
Hmm.
we have received copy. We have forwarded to the such concerned speakers,
Hmm.
part of the Paravali Kumar. Then we have to file it.
Appeal what? Paralysis. MFA.
It's an appeal.
It is land application.
Correct. Even so, it's an appeal.
Based on when you will be ready.
That, second week of next month, my lord. Well, we can restrict this for, because it's an institution, we have burden of paying interest on the award passed by the court.
It is an appeal.
Necessary burden to the institution.
Absolutely. Absolutely.
Disposal of all the appeals. In order to avoid the payment of interest on.
Only one appeal by the claimant.
Sorry, my lord.
Only one appeal for enhancement. Everything else, one appeal is by the claimant.
Well, in the other appeals, my credit is in.
All the other appeals are by the 7.5 is also by the claimant. 7.6 is by the claimant.
7. If all the appeals where enhancement was made, we have filed the appeal before one.
7, 7.5 and 7.6 is by the land losers.
Please.
Correct?
Please.
The others are by the
By the
institution. Yes.
7.5, is it court fee?
And in all these matters, interest are granted by the sum of court. Was in court, but my nerve and the strongly made a submission before this court stating that the respondent has not deposited 50% as ordered by the sum of. However, we have taken the contention in this objection to this submission, saying, wherein your lordship has ordered on ordered on 15/2023. In respect of memo of clarification filed with both of us, will be considered at the time of final disposal. Till then, whatever deposit we made, the court has accepted by making a false submission before the Salvo court stating that we have not complained. And ordered the order from the Salvo court to execute the degree. It is required to be recalled in this appeal of appeal. Appeal number 638 of 2021.
Where is the application for recall?
Appeal in appeal number 638 of 7.4.
There is no application.
Now we have.
There is no application for recall. This is the application.
Right now, my lord.
That is the order by order on the 10th. This is the order dated 5/9/2024. Common has been order has been passed by this order for the number.
5/9.
Yadra Lisa's case. It is in 6382. 6382.
638.
What is the date of the order?
5/9/2024.
5/9/2024.
Order sheet, please. 5/9. What is? There is no such order on 5/9
No, my
in
lord.
this matter.
I have a copy of the order in the common order passed in appeal number 68/29 of 2022.
9/9 is the.
Capture in the appeal was 68 of 2021.
The order was could not able to find. Please produce that. Don't precipitate now. He is saying that. Now execution court is proceeding.
Yes, my lord. They have filed execution and they have taken the delivery warrant and or everything.
Appellants are required to deposit the 50% of the award amount. They did not deposit, my lord. Award is around 1,32,62,441. Available at page number 63 of appeal memo. They are required to deposit 50% of the same amount, having regard to the order dated 5/9/24.
What have they deposited?
They did not deposit. They deposit around 33 lakhs. Even today also, while serving copy, they did not produce any proof to say that 50% of the award amount has been deposited. By the order dated 5/9, there is a liberty to the respondents to proceed with the award, execution award, in the event 50% is not deposited. Hence, we are proceeding with the execution matter. Had they deposit, we will not precipitate the matter.
My request for last to see the order dated 56/2023.
passed by this honorable court about.
5/9/2024, the order is though 50% of the award was ordered to be deposited, they have deposited less. If that case, the respondents are at liberty to execute the award.
With that, my lord, I request the lordship to return order dated 2023.
Is not here in this file. Please type in file. 3/22.
15/6/2023.
It's not 15/6/23. No, 15/6/23 in this order. Please, we'll have it on some other day. Please be ready with the orders. Please be ready with the orders.
Narayan, but you don't precipitate, because they have deposited some amount, still is pending.
Please,
Meantime, you produce those interim orders also along with memos, so that it will be easy for us.
And also show us what is the amount you've deposited.
And you should show a calculation, it should be 50%.
Yes, we will have
Not
it
like some 10 lakh or something, 33 lakh, it should be 50% of a decretal amount.
let me direction to my learned friend to produce the memo of calculation.
Memo of calculations are there.
It's available there.
They have been filed, but
Along with the proof of payment.
yes.
What about this 7.5, you have not paid the court fees?
I have paid the court fee. I have paid the court fee and produced the valuation slip also.
Council appearing for the claimant, undertake that he will not precipitate the matter before the execution for said submission placed on record. He further submits that in MFA 2271 of 22, paid the court fee, registration shall verify, see. 7.6.
7 point.
Accepted cost shown, orders on I 12, so 3 of 23, accepting the cost shown in the affidavit. Delay of 541 days in filing the application to bring the legal heirs to the appellant is condoned, abatement is set aside. The legal heirs of the appellants are permitted to brought on record. Appellant shall amend the cost title within a period of 1 week and file amended copy.
7.7. I have made an application.
7.7.
I have made an application seeking for withdrawal of the amount deposited by me. May kindly be permitted to withdraw.
In which matter, sir?
7.7.
In 7.7. Then counsel for the appellate filed an amended cost title, same is taken on the part. We'll consider that application. The records.
Appeal filed by the institution. Represented by the
Call for
7.1. Filed an application, 7.1. Filed an application seeking permission to withdraw the amount.
7.1.
7.7 also they've made the.
In respect of withdrawal of the amount, we have no objection subject to furnishing security. Subject to the.
What landowners will for it?
Security does not.
What they will give bank guarantors? What land? Are you disputing that it is not their land?
Although they are not entitled to compensation to that extent.
In which applications are pending?
7.1,
7.7.
7.1 and 7.7. Or some, heard. Matter request for consideration. During the pendency of these appeals, the appellant claimants are permitted to withdraw 25% of the amount. Claimants,
Respondent claimants.
claimants are permitted to withdraw 25% of the amount. It is 50% of the amount in deposit. Entry model granted
In fact, they have not deposited 50% of the
That
entire
will
award.
see that.
That we'll consider.
LAO award. That is the controversy before. LAO award was paid, position was taken, which is answer petition. That is to be the case, I will demonstrate from my case.
Please do take that.
Yes.
Definition of the
Please file your memo of calculations. We consider that. You take this minutes. The records are required. This is the reason we have ordered. Otherwise, we will defer the consideration application along with.
Although they have not grown the mango trees, they have taken compensation for the mango trees, for which we have.
Unfriend may not make applications on minutes, my lord.
That is on merits. We'll hear it. Please, Please reserve your resources for the final year. Yes.
I will kindly be extended in all the case, my lords.
To withdraw the amount, there is an order. We also pass the order. This should be-
In other matters, 100% of.
Whatever they have deposited 3 millions.
No, no.
Only
the
50%
Security
of
court,
the
also we have no
amount.
objection. Let the fund be security.
Alright,
except
right.
the-
No arguments on this.
Yes.
I will, I will.
All for, hey, you want to granted earlier extent.
That's one more.
All for TCR.
That's one more. Entire NCR or year three,
No.
let them release the amount based on the certified, with that observation. will be.
After release of the amount, the DCR shall be forwarded to the, that is called.
To release the amount.
It has not come, sir. DCR.
Some of the matters, NCR has come, my lord. What to
That's what I'm
difficulties
saying,
is-
It is there, please.
That is why
The reference court has declined to release the amount, saying that the entire original records are here. So that, based on the certified copy, let them do. Because there is already.
7.1 and 7.7. 7.1 and 7.7 has not come. 7.1 has come. Then 7.7.
To send back to DCR and once purpose is served. From which reference code?
Tapura.
May I request your lordship in this matter? Kindly have the matter in the second week of this next month. Dispose it off after hearing, and then send back the records along with the orders of the Sambha.
Yes.
Much of.
Yes.
We will withdraw the amount based on the certified level.
That we don't know, per se. Somebody withdraws the amount immediately.
Mm.
This is directed to
Notification is of the year
transmit
2000.
back the first to the reference code for the purpose of facilitation to withdraw.
It is only 7.1 and 7.7. Yes.
It's the date, my lord, February 2nd.
Much of.
17.
Published.
Number 8, Prashant Chandra SN.
Yes, 36/2007, the property was acquired. The contention is that petitioners along with R3, R3 is a partner of R2. Yes. So, the finding is that 24,36,000. Para 28 of the judgment is paid by the financial institution, not by either R3 or by the petitioner.
I am liable, I am responsible.
Course, that is not the question. If the amount is paid by the financial institution, then the question of punishment, etc., does not come. Then it comes within the ambit of the act. It is.
If so, the members, namely the partners of the financial establishment ought to have been parties, they are not. So I have a very serious question as to whether they're. The complaint is in the, of the year 2019. My property is in 2007.
Does not.
Complainant in favor of affair is.
The finding is nothing to do with that. The finding is simply that the entire property, the entire consideration for the purchase of the property was by the institution, not by you, not by the partners, not by anybody else.
When I purchased the property, I am only a 3/4 holder. The liability to me is that of only 1/4 holder, not me. 3/4 holder is myself. We are all
3/4 holder in the document. But the finding is recorded is that the contention and the finding is that 24,36,000 by demand drafts by the company.
Maybe. Saying that I am not responsible for that. Lordship is saying the responsibility is otherwise. My share in the property is 3/4. That should not have been attached. 1/4 is the one owner.
If the entire property is purchased by the financial institution, it have been done. But it's a first appeal, we can
And the note of
hear
this,
it on a day. It is a first appeal, we'll hear it on a day. That's all we can do. Yes. Notice. Please serve a copy. We'll hear you on a near date. We have, it is a first appeal. We cannot decide at the admission stage.
said that the other, the R3, culprit, he is also filed, so it's better that all are taken.
Yes, the Appellant shall serve, learned counsel for the appellant shall serve a copy of the appeal on the learned counsel appearing for the competent authority. Issue notice to the other respondents, list along with connected cases, if any. If you can give the numbers, it can be listed. Yes. Please show the name. Please show the name of the counsel for the.
Preliminary hearing,
Yes, list it on a near date.
preliminary hearing, still number 9 adjourned, still number 10. Chirodra Pajetka.
Contract case. Short time to get instructions whether.
Lord, in this
Yes.
matter, this is contract pertaining to 2006. Now, my lord, he's asked us to consider his representation. One is one. Or else, my lord, what he is demanding is about crores together. The amount payable is about 6 lakh, as on that day. Lord,
The amount payable as per their own notes, which are not under the RTA, nots are produced along with the application. That's the reason nots are fought for. But it's an extension of time nots to be given, but until that is given by them, not, they cannot prepare a final bill. Let them prepare a final bill.
the
whatever they are
final
trying to
bill
say.
has been prepared in his presence. And my
That's
lord,
a pre-final bill. I have myself produced it along with the additional document.
I just prepared the.
And that itself shows it is
Statement.
not, sir.
Pass over.
My lord, I
Here it-
prepared the written statement, my lord, the objection statement.
Please make it available. Serve it, please.
My lord, it could be sent to the Lok Adalat or.
Even that,
That's the only way out, my lord. Otherwise, it cannot be because he is in crores together.
the amount is in the writ petition itself, 37 lakhs. So
There is absolutely no dispute.
Hello.
There is no dispute between you, as a matter of fact.
My lord, I'll just pass on a copy of the petition, my lord. Let your lordship.
Representation, how much amount you are claiming?
Sir, claim notes 37 lakhs. I have written in the petition.
Next
in
day.
Back, my lord,
Yes, we'll say that, you can consider the representation.
Yes,
He can be heard, and whatever is the amount that is due, it will be paid within a time frame.
Open.
Yes. Heard. You've heard the learned counsel appearing on either side. The appeal is fine. By the petitioner challenging the order of the learning assembly judge, as against the order of the learning assembly judge. Dismissing the petition filed by the petitioner. The learned counsel for the appellant submits that the prayer in the writ petition was for a consideration of the legal notices with representations prepared by the petitioners and Annexure K and Annexure K1, and to take appropriate steps to make payment to the petitioner. The learned judge has non-suited the appellant on the ground that the matter is one of contract, and that since the valid contract determines the rights and obligations of the parties, a writ for mandamus will not lie. The learned counsel for the appellant submits that there is absolutely no factual dispute between the parties, and that the respondents have also admitted that the work had been completed by the appellant and that amounts are due. They submitted that in the above circumstances, the dismissal of the petition was completely unwarranted. The learned counsel appearing for respondents 3 to 6 submits that for 3 to 6.
3 to 6.
Yes.
In paragraph 6 there.
Okay, okay. Yes, the learned counsel appearing for respondents 3 to 6 submits that it is not in dispute that the appellant had been that there was a contract for the conduct of work by the appellant as claimed by the appellant, full stop. It is further submitted that the estimated work was for an amount of 82 lakhs 81,000, and that for one work and rupees 25 lakhs 60,000 for another. The works were commenced on 20/12/2006 and 8/6/2006 respectively, and were actually completed by the appellant on 10/8/2007 and 15/11/2006. It is submitted that as regards the first work, the appellant was liable to be paid only rupees 62,47,692.50 as per the actual measurements taken at the time of completion of the said work in the presence of the appellant, out of which the appellant had already been paid an amount of rupees 57,60,405.20. And the due amount therefore is only 4,87,287.74. Full stop. With regard to the second work, it is submitted that though the estimated cost was 25,60,000, after completion, it was found that the appellant was liable to be paid only 23,21,145.95 as per the actual measurements taken after completion of the work in the presence of the appellant. It is further stated that as per the payment register, appellant had already been paid 21,57,230.10, and the amount due therefore is only 1,63,915.85. Full stop. It is therefore contended that the amount due is much less than what has been claimed by the appellant. Full stop. Having considered the contentions advanced, we notice that it is an admitted case that two works as claimed by the petitioner, as claimed by the appellant in the writ petition, had actually been conducted by the writ petitioner, and that amounts are due to be paid to the writ petitioner as claimed by him. Full stop. The learned counsel for the appellant submits that the details of the amounts claimed are available in Annexure K and Annexure K1, and that the claim is liable to be considered in accordance with law, which was the only prayer sought for by the appellant in the writ petition. Having considered the contentions, we are of the opinion that the question as to the amount actually payable is the only dispute between the parties. And in the absence of any specific dispute with regard to the work done by the appellants, the claim raised by the appellant is liable to be considered by the respondents. In the above view of the matter, this appeal is allowed in part. This appeal is allowed. There'll be a direction to which respondent has to consider.
Second respondent. 3 to 6, my lord, but to be considered by the chief engineer.
Fourth respondent?
5.
Five. Who has to consider? Please tell us.
Chief engineer, my lord, he is in charge.
5. There'll be a direction to the fifth respondent to take up Annexure K, Annexure K1, and any further representation that the petitioner may wish to submit before the fifth respondent, and to consider and pass orders on the same after hearing the petition. The amounts found due to be payable to the petitioner shall be paid with interest as provided in the contract.
Interest,
Interest, if any, as provided in the contract.
let that interest part not be there. I understand. I'm not disputing it all.
No, if there is a contractual interest, you must.
My lord, only one submission, my lord. The amount, my lord, what my learned friend says, he is accepting the amount what we have said, 6,05,000. Whatever the balance as per that is.
Not adjudicating
No,
on
no,
the amount paid.
Only one
It is for you
submission,
to do.
only one submission.
Yes,
That is the amount what he says, and
Yes.
he says EMD has been deposited.
yes,
That may be notified, my lord, and they will consider in that respect.
yes. The claim of the petitioner for refund of the EMD deposit, earnest money deposit and any other amounts due will also be duly considered by the fifth respondent.
6 lakhs 5,000.
Admitted amounts.
Yes, 6 lakhs 5,000.
Of rupees 6 lakh,
5,202.
that is the earnest money deposit or?
That is the pre-final. According to him also, that is the
Never.
pre-final bill I have produced.
The admitted amounts, if any, found to be payable to the appellant shall be paid forthwith at any rate within a period of
2 months.
6 years admitted amount.
6 weeks from date of receipt of a copy of
I have
this
applied.
judgment. Do you want a time limit for the consideration?
That is 6 weeks, Your Honor. For consideration of the representation.
Consideration 4 weeks. And the
Thereafter 4 weeks for payment.
thereafter 2 weeks for payment. Yes, this is already admitted. amount.
Obliged.
Yes.
11, Manuke.
Housing
My lords,
board.
I appear on behalf of the appellants.
Hmm.
My lords, there are discrepancies with respect to translated copies, and I want to clarify the same. If 1 week time is permitted, my lords, I will file the fresh translation copies.
The learned counsel for the respondent says, on
Yes,
the
my
same
lord.
ground, you've already taken 3 adjournments. Is that correct?
My lords, I was supposed to get instructions from my client with respect to deposit of the amount as well.
That is
My
also
lords,
there.
I've requested
We are,
instructions
we
from
are
my
granting you one last accommodation.
much
a
obliged,
week's
my
time.
lords. Much
If
obliged,
it's
my lords.
not done in the meanwhile, the next posting will impose exemplary costs.
Oh, my lords, we will appear on the next
House-
date and we'll argue. In fact, we have already filed our synopsis, my lords. This is the only thing that we'll have to.
Filing of the synopsis
My lord.
is not enough. You must be ready to argue the matter also.
Yes, my lords. 1 week time.
Yes, the learned counsel for the appellant seeks a short accommodation of a week to be ready to argue the matter. List after a week.
Finally, my lord.
Give a date.
Much obliged.
28, 1.
Obliged.
Hearing on IA, number 12, Mahesh YL.
Lords, I appear on behalf of the appellant in this matter. Lords, the appeal was dismissed for non-prosecution. I have filed an application to restore, and there is also a delay in filing of this present application of 113 days, my lords. Notice was served to the respondents on the previous day. Acknowledgement has already been filed.
Appearance also. There is appearance for the respondents. All the respondents?
Yes, my lords, I have served, my lords. It was represented by one single counsel. I have served it. I have also produced the acknowledgement, which is filed before the court on 22nd of August, 2024.
There is appearance. What about R1? R1 does not appear to be served.
R1 is dead, my lords. R1 is dead. R1 is my own brother.
Yes.
Non-prosecution.
For non-compliance?
Non-prosecution, non-compliance and non-prosecution, because
What is a non-compliance? That is,
Lords, I have complied with that.
that has been complied.
That has been
You
complied
sure?
with.
There is-
Absolutely. It's complied with. The previous advocate issues NOC, after that does not inform us that the matter was listed. He files the same before the court memo of retirement, and this honorable court dismisses the appeal. My lords. That is what has happened. The lady is 69 years old as of now.
For admission.
Yes.
Admission.
we-
Deeply obliged.
We're listing it for admission.
Yes, my lords.
30, Umesh BN.
For respondent number B, C, D, there is a settlement talks are going on. Kindly grant 3 weeks.
In the LS have to be brought on
Yes,
record,
yes,
don't
sorry.
they?
Yes, that's
Yes.
As a matter of fact, my lords, section 263 come in the way of this appeal.
Oh,
This is a challenging probate order. But anyhow, my lords,
Even
LR
though if
application
there's
may
a-
be allowed. So
if there
that
is a
proposal for
chance of
settlement,
settlement,
please,
then-
we will do that, ma'am.
it needs to be allowed.
Please.
Yes.
And one, lords, I'm filing a memo. Even second appellant is no more. So our LR is already on record as appellant number 1, my lords.
Yes.
Memo.
Memo indicating that.
Appellant
Second-
number 2, my
second
lords. Appellant number 2.
Appellant number 2.
whose LR is already on record as appellant number 1, mother.
Treated as appellant number 1 is treated as a legal heir of the appellant number 1.
No, two.
Appellant
Appellant number 1 is legal heir of appellant number 2.
the appellants are-
Please.
We list this after
3
4 weeks.
Yes.
Please.
So that in the meanwhile, please.
Publish.
17th February,
Release of deposit land acquisition.
14.
I prefer respondent in this matter, please, my lord. On the last occasion,
Just a moment, please.
Same notification.
I prefer respondent, please. On the last occasion, appellant has submitted one judgment, please, my lord, that cannot be relied upon for the reason your lordship may kindly see that that is a small portion of 2,400 square feet of Kata land, wherein 60 rupees was granted earlier and subsequently it was enhanced to 250 rupees. That is a writ petition filed by Venkata Ramanaya, the aggrieved party, not by the special land acquisition, please, my lord. In fact, for the same same place, please, my lord, I may take your lordships to the judgment produced by them, please, my lord. Para 2 of the judgment. Facts leading to the filing of this appeal briefly stated as follows. Appellant was the owner of the land measuring 2,400 square feet situated at municipal Kata number 1224 of Jodi KRS Agrahara Kunigal. The aforesaid land along with the other lands were acquired for formation of Bangalore Hassan railway line, please, madam. May I, I'm passing on one, this one, please, my lord. But by the same, for the same land, I'm sorry, it's incorrect. I thought. The lords may kindly see. I'm sorry, just now I got this. I could not get it translated, please, madam. Next page, please, my lord. Para 30.1. Otherly, the lords may kindly see. For the same place, please, my lord. That's the reason I read the para 2. Jodi KRS Agrahara, that is the place. Here you lords may kindly see Hasana Bangalore Railway ಯೋಜನೆಗಾಗಿ ತುಮಕೂರು ಜಿಲ್ಲೆ ಕುಣಿಗಲ್ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಹೇರೂರು ಗ್ರಾಮ ಸೋಣಸು ಕುಣಿಗಲ್ ಕಸಬಾ ಜೋಡಿ KRS ಅಗ್ರಹಾರ ಸರ್ಕಾರಿ KRS ಅಗ್ರಹಾರ ಮತ್ತು ಲಕ್ಷ್ಮೀಕಾಂತನಹಳ್ಳಿ ಗ್ರಾಮ ಒಟ್ಟು 4 ಎಕರೆ 21.5 ಗುಂಟೆ on 26/7/2016. Last may kindly see that column, please, my lord, ಕೆಳಗಡೆ ಜೋಡಿ ಅಗ್ರಹಾರ ಭೂ ಪರಿವರ್ತನೆ ಆದ ಜಮೀನಿಗೆ 700 rupees per square feet. ಭೂ ಪರಿವರ್ತನೆ ಆಗದ ಪುರಸಭೆ ಖಾತೆ ಹೊಂದಿರುವ ಜಮೀನಿಗೆ 600 ರೂಪಾಯಿ. So 700 rupees and 600 rupees have been fixed. That has been released also.
2018.
Yes, my lord.
Notification is of the year 2014.
Yes, my lord.
7/10/2014.
Yes, my lord. Thereafter, that has been, in all 4 acre 21 guntas have been acquired. For that, this amount has been discharged, 700 rupees and 600 rupees. I hope by the time these orders was passed, that person who has acquired this 2,400 land, he must have been already received 700 rupees or 600 rupees. That is the reason he may not have been informed to the advocate on record as on that day. That is the reason this must have been disposed of. For the same, please, madam. Yes, ma'am.
Not pertaining to same notification.
Same, please, madam. Same. That is the what? That is what I am producing. Yes, same. Same.
What you are producing this?
This is, no, please, madam.
Can't give like this.
My lords, no.
And please give me a translation as well.
Please,
Please
please,
provide a translated copy,
please, madam.
without which we cannot
I'll-
go ahead with.
Appeal like this. It's not a writ proceeding. This is a first appeal. You can't produce like some chit here.
No.
It is not
Whatever the
a,
documents are there, you argue.
it is not a judgment that you're producing. It is something.
No. This is KIDB. This is the land acquired for Hasana Bengaluru Railway ಯೋಜನೆಗಾಗಿ For railway department has only acquired the land.
In 2018.
Yes, my lord, 2016, prior to 2016, in 2016, they have fixed this price. Even including this judgment acquired.
An appeal council.
Yes, my lord. My lord, this
Please argue
totally,
the appeal. It is an MFA you're arguing.
yes, my lord, we have filed cross appeal also, cross CROB we have filed for enhancement. That is also connected with this. The last occasion, my learned friend is relying on the judgment wherein 250 has been reduced to 200 rupees and the health idare. That is the reason I'm submitting the KRS Jodi Agrahara for the same place.
Some
Sir.
correspondence of the SLA or KIDB, you can't give something
Not-
there and say that
It is,
800, 1000.
my lord is not,
And
no, that has been decided, please, my lord.
Just a moment, when is your notification?
My lord,
When is the notification we are considering?
sorry.
When is the preliminary notification? When is the final notification?
Sir.
Even
Notification was issued on 18/1/27.
final notification on 1/11/2007. Award passed on 16/2/2009.
Yes.
And what are you relying on?
No, for same Jodi Agrahara place, I'm saying that amount is fixed for,
Payment of the court, give us. 900, 1000 rupees, 10,000 rupees, give the judgment.
that is what decided by, first page, you lost me kindly. Whatever, sir.
Which court?
No, KIDB, it said they have only fixed this amount.
It has not acted on this land.
No, for, yes, my lord. For development of Hassan Bangalore Railway Yojana ID, Kunigil Taluku, that's what I read this portion.
Council, today,
I'm sorry.
today the price of the land will be much higher. Will that help you? Today, you can produce documents showing that the price of the land is much higher. Notification in 2007.
2016, sir. Some
Yes, yes,
representative
ma'am.
of the KIDB
How can it
paper
help
says,
you?
Can we consider that and grant 900 rupees?
Yes, my lord.
So your evidence, what you have adduced.
Yes, my lord. We have also produced documents to show that as on that day, what,
Get ready and argue.
Your appeal, not some other matter 10 years later. Please argue your appeal.
please, ma'am, may take them. Day after tomorrow it can take. I will get ready. in
Pass over, pass over.
Wednesday. please.
Please, we are right. Don't want to forget.
15, Unikrishnan.
984 days delay.
100 odd matters.
Hmm.
For 4 matters, my lord, we are not able to comply with authorization. That is how it was dismissed. File my personal affidavit. Mistake from our office. My lord, I am willing to deposit the entire word amount which is
What are the office objections?
My lord, office objections, everything is now compliant, my lord. It's now come up for. Matter got, got dismissed. And then we could not comply because matter was dismissed. Only after this road I can now comply with the main.
Will office objections are there?
That is because, my lord, only in this road only they will allow us to comply.
No, that will, pending consideration will permit you to comply with the office objections. Then we'll list it on, yes,
I'm willing to deposit the entire award of.
comply with the office objections first so that we can recall the order. Yes.
Finally, 2 weeks' time is granted to comply office objection. To consider the pending applications. To stop. If office objections are not complied within a period of 2 weeks, all the pending applications stand rejected without further any reference to probate.
The appellant is permitted to comply with the office objections. Yes.
Appellant is permitted to comply with office objections. Compliance.
16.
I am for the
Raju?
appellant. For the land acquisition matter, my lord. Appeal by the claimant for enhancement is rejected for non-compliance of office objection. The main office objection is, my lord, regarding non-payment of court fee. I am required to pay court fee of around 3,25,00,000, my lord. I could not arrange due to pandemic. Now, my lord, within 2 weeks, we are ready to comply with the office objection and pay court fee, my lord. I request your lordship to recall the order and restore the appeal.
We'll pay the interest for all these.
My lord, interest may be denied, my lord.
According to your ledger, you will come to pay the court fees.
My lord, interest, my lord, we will not claim any interest, my lord.
Condition may not.
That may be denied, my lord, subject to that, my lord.
Appellant is permitted to comply office objection within a period of 2 weeks. If office objections complied, list the application for consideration. Made clear that if office objections are not complied, pending applications stand rejected without reference.
Please,
to the bench.
please, much up.
17. Monesh Kumar
This
K.
matter, my lord.
Hearing for respondent, my lord.
As per the court order, we have deposited 50% of the amount.
I have filed an application, my lord, seeking withdrawal of 50% of the amount. In similar matters, my lords have permitted me to withdraw.
50% of the amount in deposit.
Please, ma'am. Before the reference code, they have already deposited.
Entire amount is deposited.
No, subject, my lord, IA 1/24 came to be, my lord, the notice was issued, subject to they depositing 50% of the amount before the reference code. Now that my learned friend has submitted, he
On
has
September 26, we have deposited.
Are you seeking withdrawal of the entire amount in deposit or 50% of the amount in deposit? What are you seeking? And what has been ordered in connected cases?
Yes,
I have a copy.
50% of the award amount that has been, my lord, now deposited.
Whatever has been deposited, you have been permitted
I
to
have got-
withdraw. In
Yes.
connected cases also, that is the order.
Please, my lord.
Which is the connected case? Not seriously disputed.
Yeah,
50% he can be permitted to withdraw.
Not been served a copy, my lord, I'll see. IA copy.
I'll serve a copy.
Please do the needful.
And
Yes.
We also don't have a copy. In which is the connected case
I'll-
where
my lord, I request to have this matter next week. So that I'll seek instructions. Short question.
For the R1
SLAO,
PV Chandrasekhar. PV Chandrasekhar is request to set up for respondent. When comes for the application, sir, set up request to AD Veselio.
No, I am for BWSSP.
databases.
Who is R1?
R1 is KD.
Special Land Acquisition Office,
KD.
KD. no?
KD,
PV, sir, PV Chandrasekhar.
please.
Obliged.
Next.
Any date may be.
Copy of.
Please
I'll
make
send.
available the copy or at
Please,
least the
ma'am.
number so that we can.
The previous orders, yes, please. May I request for a date, my lord, next?
Yes.
28.
Please.
18. Arun Kumar.
For the appellants, my lord. In the last hearing, the honorable court has said to, instructed to go through the section 263, my lord. To file it in front of a district court. The humble submission is that the appeal was filed under section 299, my lord. If the honorable court directs and passes the necessary order to file in front of district court, we will do it, my lord. But the only thing is, IA number 1 and 2, I'm pressing on IA number 1 and 2, my lord. Because already there was technically a delay of 147 days. Now almost another 45 days has been added, my lord. And IA number 2 is to stay the proceeding because the respondent is already entering into a sale agreement, my lord.
Have you seen the judgment?
Yes, my lord.
Have you seen the
Yes, my
judgment?
lord. Yes, my lord.
What do you say about that?
We will file in front of a trial court, my lord. I press on IA number 1 and 2, my lord.
There's a delay here. Which ones?
Very purpose of.
Appellant number 1 is the wife of the deceased person, my lord. Only till the respondent comes on the record, if it has been allowed, that's enough, my lord.
Yes.
current counsel for the appellant and the expert submits that he intend to
Lordship,
file a petition under section 263.
263.
263 of the Act 1925. Seeking revocation or annulment of the order before the claim said submission is placed on record. It is further submitted that the appellants, the respondents are, what they are doing?
trying to alienate the property, my lord.
To eliminate the property. Once he seeks interim protection for a limited period. Wife of the deceased.
Wife of the deceased. First appellant is the wife of the deceased.
Yes, my lord.
They have considered view that the appellant be permitted to approach the same court under section 263 of the Act seeking revocation of the order dated 3/4/2024. However, he is permitted to file the application or petition before the appropriate court in a period of 4 weeks. In view of the officer's submission that the respondent children, no?
Yes, my lord.
Children.
Appellant number 1 is a wife. Appellant number 2, 3, 4 is children, my lord. One of the child, my lord.
Daughter.
Daughter, my lord.
Property. Consider to that the interest of justice will be met if the respondent is restrained from dealing with the property for a period of 6 weeks.
Yes, my lord. Much obliged, my lord.
For the opposition reasons, we proceed to pass the following order. The appellant is permitted to file a petition 263 of Science Act seeking for revocation of the order dated, amendments, revocation / amendment of the order dated 3/4/2024 passed in B&SC 48 of 2023. The appellant shall file the petition within a period of 3 weeks.
Much obliged, my lord.
Today. Meanwhile, the respondent number 3 is restrained from dealing with property in any manner for a period of 6 weeks.
Much obliged, my lord. Much obliged.
The above, release.
Orders, seal number 19, Satish R. Girji.
They sell 151, we have a price in series. And we can exercise that.
That one will be there.
Without continuing the power the 161. Keeping in mind the fact that the respondent terminated the property, we need to meticulously explain as well as the very claim of the appellant will be defeated.
Yes.
Right with act.
Satish R. Girji.
Move for retirement.
Unconscionable judgment has filed a memo of retirement without the acknowledgement for having returned the papers with the NOC. Hence, the memo of retirement is rejected.
20, yes, Sajesh Kumar.
Lord, appearing for the appellant, my lords. On 12/6/2014, my lords, this court had ordered that the FSL report be filed, my lords. 12/6/2024. Since that date, my lords, multiple occasions have been granted, my lords. The FSL report has still not been filed.
2 weeks time may be granted for
take the report from the FSL.
The date, my lord.
It's pending before the FSL, my lord. We are continuous follow-up on that regard.
From 12/6.
Please, my lord.
The
More than
outer
6
limit
months.
granted was 6
They
weeks.
have to send, my lord. We have sent the copies to the FSL. From there, we are waiting for the report, my lord.
55,000 rupees also paid. Initial payment. 20th September, several postings given. That's a report, I think, about the.
What is the reason why it is sent clearly?
That,
We have paid, my lords. I for the appellant.
that is not the question. Why was it sent for an FSL report? Because the,
This matter.
Signature.
It is the appellant's contention is that the document is bogus. But on that basis, this honorable court was pleased to send it for FSL.
Yes, my lord. We have sent the documents to the FSL. They are due to their crowded.
please,
We'll
take
follow
it
it
up
up.
with them. 12/6/2024,
Please, my lord.
it has been ordered and 6 weeks time has been granted.
Please, my lord.
Thereafter, several adjournments have been
Please,
given
ma'am.
for this very purpose.
Immediately we'll follow up, my
Please
lord.
see that it is, please
Please, ma'am.
follow up and see that it
No,
is
please,
on
my lord.
record.
Please, my lord.
See, 6 weeks time to place the FSL report before this call. The article 24 indicate that if the report is not filed within week, the stringent action may follow. Thereafter, a sufficient time is granted despite the report is not filed. Finally, week's time is granted to place the FSL report before the court, failing which Director FSL, ASFSL, Karnataka State Cooperative, FSL shall present to the court to give explanation as to why action shall not be taken against him for not compliance with the order. The order of today's order shall be communicated to Director FSL. I think you will tie the file, keep in the AG office and run away or what? Where are the communication? If it is not there, then we will write against the AGs also. We can't make such casual submission. What is this stringent action?
21. Raghavendra K.
I served a copy upon my land friend. Ma'am. Copy has been, paper books copy I served it.
LRs of R1.
Lord, I have to file the second set to bring the LRs of the second on record. Ma'am. I'll file it.
You are appearing for LS. Yeah. Allow that application.
Lord,
I have received the second.
Matter pertains to the non-payment of duty and penalty on the unregistered document. Date and showing the
To Akshan, I 1 to 4. Second partial. Delay is there.
delay.
But in this, the layers of respond number 1.
Only one respondent.
Respond number 1.
Please.
Only one respondent.
One respondent, not is I'll amend. I will right now I'll amend. My lord, may kindly record that I have served the copy of the paper book to him also.
1A to 1E, my lord. 1A to E.
Please. Please.
Is it delay? Delay, alert. The delay of 1,123 days.
COVID-19 ಅಲ್ಲಿ ಇದ್ದಿದ್ದು it can be condoned. Delay may kindly be condoned.
Are perfectly brought on record. Appellant shall amend the cost item.
Please, I'll file a separate amended cost title. Please.
1B.
Please.
The respondent accepts the acknowledgement of receipt of paper book.
Please,
Yes.
date may kindly be given, my lord.
Lord, in this matter, my lord, almost all the papers are in Kannada. I have to file the translation, including the judgment. Just now I saw it.
Bari judgment on the Saab rigor.
3 weeks.
3 weeks. After 3 weeks. Give a date.
Date may kindly, because 2015 appeal
February.
itself is 2015.
12th February.
Please.
Much.
22 is Sushant Venkatesh.
Memo of compromise.
Disputes, my lord, are settled. A compromise petition has been filed before your lordship, but there's one small mistake, my lord. Instead of signing for applicant number 2, they've signed for applicant number 1. Applicant number 1 has already passed away.
Okay.
So that one correction we'll have to do to the joint memo. All parties are present.
That correction will have to be carried out in the memo.
In the memo, because
We'll have
the
to
only the
return-
last page, instead of writing applicant number 2, it's written as applicant number 1.
Be returned for the correction. All parties are
Parties
present.
are here.
Parties are.
Parties.
Nobody has any objections to the
Because-
corrections being carried out.
Done in mediation, Lord, before mediator and then joint memo is filed. Correction, madam. Allah, in the joint. Joint compromise. Is it there? This is-
Please give the joint.
Appeal number. It's also
Last,
last one.
this is second applicant.
Yes. The appeals will stand now decreed in
Yes.
terms of the compromise.
Please.
It is submitted by the learned counsel appearing on either side. That the appeals stand compromised between the parties, that a compromise has been entered into between the parties, which has been reduced to writing and duly signed by the parties. Full stop. It is submitted that in view of the compromise entered into between the parties, the appeals can be disposed of in terms of the compromise. Full stop. We have perused the compromise entered into between the parties. The parties are also present before us, and they submit that the matter stands settled between them in terms of the compromise entered into. The said memorandum of compromise petition and the agreements are therefore taken on record. The appeals are decreed in terms of the compromise entered into between the parties. The impugned judgment and decree shall stand modified to the above extent, and the party shall comply with the terms of the compromise as decreed.
Great, obliged.
The parties are present.
DN Butcher.
No.
The parties as identified by their respective
Dilash.
councils are present.
Please, yes. 2 and 3
Sanjeev
are
Kumar.
represented by 3, my lord.
Arun Kumar.
Others.
Please
Arun
sign
Kumar
the,
is present.
Is present. Obliged.
please get. Please take that names also. Signature. Sir, signature.
Twenty-three.
Appearing for appellant, my
Please.
lords.
Please mention the name of legal counsel also.
My lords, appearing for appellant, my lords, the connected matters are reserved for judgment in WA 34 of 21. There are certain office objections that were to be complied with, which we'll do, my lords, against A6. Other respondents have filed vakalat.
May I make a submission, my lord? I am for the respondent. I have a submission in respect of office objection number 3, my lord, that hand summons in respect of R6 is not taken. My lord, R6 is died on 20th/4/2021, my lord. In respect of him, it may be, proceedings may be abated, my lord.
Held abated. record this.
My lord,
R6 slide. Feel R6 stand abated statutorily. To take steps.
my lord, there are other connected matters. May I pass on the number to the court officer, my lord?
Weeks time.
This is the GVP matter.
Please, your lordship. That your lordship heard in respect of regularization, and this is in respect of inquiry, termination without inquiry, my lord.
There was another matter which came up last day, Friday. What did we do with that?
84, my lords. 84 of
What did we do with that? It has been listed.
Yes, my lords. I think 2 weeks' time was given.
Yes, list along with the other. And the office objections shall be complied with by that.
24, that's here.
Race club. Race club, this has to be heard.
For the respondent.
Umapati, party in person.
Second set not filed. Statement of objection filed by R2.
I represent R1, your lordship.
Who's R2?
R2 is party in person, Umapati.
R2 is the party in person.
Objections.
Objections.
Objections, second set.
And he's also not produced the postal receipt.
We shall throw down for the respond number 1. It's not a English for the other, as well as respond number 2 party in person. The 2 weeks time is that. Need to.
25, Gautam Devulal.
Kindly pass over, madam.
ED, what is the matter?
Kindly pass over the matter.
My lord,
My lord, this is the.
17/9/2024, there's an order passed, my lords. My lords,
My lord,
similar-
we have prepared the documents, my lord. I'll serve it to him in the course of the day, or if it is passed over, I'll give it
You can have it tomorrow then?
tomorrow, my lord.
Please,
Yes, ma'am.
Tomorrow.
please.
Obliged.
So the office objection will stand complied with during the course of the day.
Yes, means, my lord.
The office
we have-
objection shall stand complied with during the course of the day, list tomorrow.
My lord, if it is translation and other thing.
Never mind the translation.
Yes,
Only what you're specifically relying on, have the translation ready.
yes, ma'am.
Yes.
Lords may recollect, this is a matter that had come up last year. Similarly placed properties, my lords, where the orders that were passed that there's an abandonment of the scheme, and the matters went up till Supreme Court, and Supreme Court has confirmed those
Which
orders.
is the scheme?
BTM 4th stage, my
My
lords.
lord, we have answers to all his questions, my lord.
Tomorrow, day after. Listed.
Please, ma'am.
Can be heard. Yes.
Tomorrow.
It has been utilized also, roads are also found, my lord, everything.
That is on the merits. Please comply with the office
Yes,
objections.
ma'am.
Yes.
Let him serve on us. We'll serve a copy on us. Tomorrow we'll respond.
Okay.
Obliged.
Twenty-six Arjun, 27 Sharvanayas.
Goes to R4, R7, weeks time. No representation, weeks time.
28 Maruti GB.
I'm offering for petition, madam. I will kindly 2 week time now.
This time notice Shara received, addressee left. R5 to R7.
Sir, I take a
Addressee
step.
left,
kindly 2, please.
2 weeks time.
29
This matter, my lord, the KIDB had acquired the appellant's property. However, my lord, the acquisition came to be quashed by this honorable court. So far as the appellant's property is concerned, that was confirmed up to Supreme Court. Now thereafter, what had happened, my lord, there was no independent access to the appellant's property. That was the issue before the learned single judge. Learned single judge has directed that there should be some kind of road access to be given to the appellant's property. Now, my lord, what has happened? KIDB recently passed a board resolution I have a copy on my learned friend. Kindly see the map, my lord, which I produced at the end. The learned single judge had directed the KADB to come up with a road access to the applicant's property. Kindly see the map at page number 13, document number 4.
Yes.
Left-hand side, my lord, in the map, the purple portion, there is a 32-meter wide road, which has now been proposed.
32-meter wide.
Please, my lord. On the
Yes.
That road, my lord, ends at property number 127 and 128. That road, if my lord goes through that road, the last where it ends is at the plot number 127 and 128. Let's got it, my lord. Let's take my, I had just marked because this was an RTA application, I could not make any corrections to that. If my lords can say, take my notes, it will be better.
Yes.
Now, all I'm seeking, my lord, is if access is given through that road to me, that would solve the entire dispute.
Which is your property?
The one which is marked.
The purple part.
Adjacent to the purple part, the one which is marked with slant lines, my lord. Yes, that is my property.
127, 128,
Yes.
129, etc., etc.
Yes, those 8 plots, 126, 127, 128, 129, 123, 122, 121, and 120. Those 8 plots are belonging to the appellant. The learned single judge had directed to grant them access to a different route. However, my lord, now that KADB has come up with a road, alternative road for their own purpose, which is on the left side, that is the purple mark portion. All I'm asking, my lord, is let access be given to me through that road. Ultimately, it's a road, it's a public property. Now, all I'm seeking is, my lord, to access my property and to develop my property. If access is given to the appellant through that road, that would solve the entire dispute because there's a positive direction.
Can you get instructions of the matter?
Please, my lord.
If that is
Your lordship,
agreeable to them, that would be the end of the.
we'll check in section regarding
Because
that.
ultimately, my lord, there is a direction to give access. Instead of forming a separate road altogether. As and when they develop further, this road has to cut through my property.
Please, my lord, I understood totally. I will check in section.
There was a direction also.
There was a direction.
Office objection. So far as they are concerned, they had to file a compliance affidavit. How they would give the grant the road to the appellant. Through this method, it will solve the entire dispute.
So when?
By next week, my lord. Next Tuesday.
The learned counsel for the appellant has placed a
IA for direction.
PA on record. It is submitted that copy has been served on the learned counsel appearing for the respondent KADB as well. The learned counsel for the KADB seeks time to get instructions. List next Tuesday.
Please. Oblige. Great.
28-1. Number 30.
The appellant in this case, my lord. My lord, with regard to the non-filing of amended cost title, my lord, I'll file within 1 day, my lord. Non-amended cost title, my lord, approved now, my lord. I have filed an application, my lord, 6 applications, my lord. IA number 1 to 3 and 4 to 6, my lord, to bring the LRs of deceased R6 and R7, my lord. Notice has to. Yes. My lord, I may be
make a
permitted
submission,
to
my
take
lord.
hand summons, my lord.
May I make a submission, my lord?
R1 to R7.
IA number 1 to 3 in respect of respondent number 6, my lord.
6, 7, 8.
7, 8 in respect of the LRs of R6.
4, 5 and 6 in respect of R7.
R10.
R10.
Oh, sorry.
R10
R10.
also dead. R6 and R10 are dead.
Yes.
In the case of R6, 7 and 10.
Yes.
Hand summons.
In addition, and the applicant is also permitted to break out hand summons on.
Please,
May I make a submission, my lord?
Yes.
I appear for respondent number R1A. I had filed a memo, 1A, my lord. Serial number 3 of the office objections. I had filed a memo on the 23rd of July, 2024. There's a small office objection with regards to the documents not being annexed as true copies. I may be permitted to rectify those aspects, my lord.
Yes.
Published.
Grateful.
Objections or memos are also permitted to be, shall be complied with the memo.
Grateful.
Yes.
31, government advocate.
A week's time, we got to take the steps, madam.
Mm, mm.
32, Yashas.
That also 2 weeks time. Mm, mm, mm. Plan number 1 is father. 1978 grant. 1996 alienation. Conversion obtained in 99. Second sale in 2004. Ground is first application in 2006. Hmm. That's it.
Each time is granted, take steps. Uncertain, 3 and 4. List on sites.
$33. Anuparna Babu.
This case
Village, my lords,
respond.
may be permitted to comply with the office objections, my lord, given some time. The fact that they have filed an IA for withdrawal of the amount, my lords, I need to file objections for the same because the amount, they are not entitled to the same, my lords, because whatever they were entitled to, they have been already.
I filed the application to withdraw the amount, my lord. Already in
50%.
2024 is deposit before the trial court, madam. 12/1/2024.
My lords,
Dismiss the appeal. You are not filed second set of the appeal.
no,
Dismiss the appeal.
but
For non-compliance officer being 5th time.
my lords, I may be given a week's time, my
Which
lords.
is this authority?
Railways, my lords,
Dismiss.
my lords.
One more than 1 year.
One opportunity may be given, my lords. I'll comply with it, my lords.
5 times to file a second set. The railways.
My lords,
Be not-
I apologize, my
Must
lords.
be not paid.
I'll pay, I'll do all the
What about
required.
the 50% amount you have deposited?
Yes, my lords, we have
Before
deposited.
trial court.
Also,
12/1
File the acknowledgement for the same.
12/1/2024 is deposit with the trial court.
Will not comply, will not enjoy the deposit amount.
My lords, I may be permitted to comply and I'll also file the objections for the IA, my lords.
For 5th time. Finally, 2 weeks time is granted to comply of this rejection. Failing which appeal stand rejected without reference to.
Withdraw the amount of 1 year is without interest.
yes.
Next, yes.
Grateful, my lords.
A date may fix me.
Up to weeks. Please make note of the date.
I'll,
3rd February.
3rd
February. 34.
grateful.
Appear the respondent number 2, filing second set. Clubbing application filing.
May I make a request, Milord? Let this be listed for admission. That is pending admission, notice was issued and interim order was granted by your lordships.
In your.
Matter requires to be admitted or to be disposed of at that stage itself. Kindly permit me to elaborate it little further.
My lord, filing a clubbing application.
1 minute.
Filing a clubbing application, respondent number 2.
The matters.
No, that is not similar matter. It's a single judge matter. He rules the right of appeal if there's an adverse order or the other side would. That is to be considered along with the main. Milord, we are also filing application for the interim order. We'll file it in the office. Milord, I will make my submission in 2-3 sentences, Milord. A Sauharda Cooperative Society whose business is
Four pays for respond number one.
it could be admitted, listed for admission tomorrow.
You appear for respond number one.
No, I beg to appear, I beg to appear for competent authority, please, my lord.
Yes. Be listed for admission.
Please, my lord.
Urgency is there, fix the date, madam.
Tomorrow, if it's possible. If it is possible, tomorrow.
Please.
That the office.
Office objection, his
Already
objection.
second set file complied. Oh.
Yeah, your lordship could say that application is to be considered along with the main.
Let him file in the register.
He has filed it.
File in the register.
Okay. When, tomorrow.
List for admission next week.
But anytime after 27th, my lord. No, anytime after 27th, my lord, subject to my lord's convenience, my lord.
27th
Please, my lord, please, my
for
lord.
admission on 27th.
For admission.
Please, please, please.
Tomorrow, what date?
27.
Delays.
27.
There's
Delay.
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 Well, 27th will be in Dharwad, I'm sorry.
Delay is there.
27th will be in Dharwad. It could be,
Is there delay in filing the appeal?
no, there is no delay in filing the appeal.
Then list it on.
No, 27th I will not be. Your lordship would hear this only on Monday, Miller. I'm sorry, I should not.
Admission, why are you-
Monday, in next 27th na irudilla.
Sir is already admitted.
I thought my lord heard the matter. My lord has admitted. I was under the impression that I had issued notice. Then it could reconsideration of the application. We have both the applications. Except next
Yes, we'll just
Monday.
next. List
Yes.
next week, we'll hear you.
Date, which date, sir? Senior, ಯಾವ date? Date.
ನಾಳೆ ಆಗುದಿಲ್ಲ.
Today is some other banks.
Unless it is for fixed for to be Monday, it could be fixed on any other day of this week.
Your senior is convenient date. ಯಾವ date is?
28th, my lord. 28th, subject to my lord's convenience, my lord.
28th?
28th.
my lord.
Yes.
28 one. 35. Srinivasvi.
Please for appellants, my lord. I request for 2 weeks time, my lord.
Weeks time. Wait 2 weeks. 2 weeks.
My lord,
Order may be extended.
with my lord's kind permission, my lord, with the lord's kind permission. My lord, the interim order has been granted till the next date of hearing. My lord, this is a case where there has been a malafide transfer, my lord. Would my lords permit me to go on with the optional proceedings without creating third-party rights, my lord? I'm ready to argue on the merits of the case today also, my lord.
A week's time, my lord.
But after a FIR is registered, the property comes to be gifted by the grandmother, my lords, to the granddaughter. There is no dispute that she was the president of the financial establishment. So this is a clear case of malafide transfer, my lords.
Service is not over. Service is not complete. Viresh, why should we interject such? That cannot be correct. Let it be.
No, my lord, my only submission is this, my lord. I will not create third-party rights, my lord. I will not create third-party rights. Only, my lord, purposes of valuation, my lords, and doing all this paid work of auction proceedings, I may be permitted. I will not even issue, my lords, the auction notification without my lord's permission, my lord.
You can modify. Put it orders. First for the respondent submits, respond number one submits that the appellant is dealing the matter by not taking the steps.
Lord, a week's time may be
Indicates
granted.
that the absolute interim order granted is by this court. Today order dated 13/12/2024 is coming in the way of competent authority valuing the property. And what is the further steps you are required to take?
Auction first.
Valuation is one aspect. What is another?
Well, once the valuation is done, my lord, nothing else, my lord. We'll have to issue the notification, my lord, auction notification, my lord.
Full stop. His submission is based on record. the matter requires detailed consideration. Hence, the interim order dated 13/12/2024 is modified to the effect that the first respondent competent authority is permitted to conduct a valuation of the property. However, he shall not conduct any auction until further orders of this court.
Please, bro. But valuation and other steps required, valuation and other steps required, I will not issue notification.
I also take other steps required under the
Please.
provisions of the KPID Act 2004.
Please, bro.
However, he shall not
Issue
conduct the
a,
auction.
please, bro.
Do auction notification or conduct the auction without
Please.
without the leave of the court.
Obliged, bro.
Weeks to
Much
comply.
obliged. Great.
That other steps can be.
Mm.
It will be dismissed automatically at least one month.
Obliged.
36, Kavita Damodaran.
My lords, for the appellants in this, my lords, the only office objection that has been raised is there is a mismatch in the seal. And in all the affidavits, they have annexed to the correct seal, my lord. Only in the wakalat, they have misplaced it. So a weekday may be, I mean, not my lords, a day may be given, my lords. On 22nd, the matter may be listed. We will file it today or tomorrow, my lords.
Learned counsel for the appellant submits that the office objections raised will be complied with within a day. Time granted as sought for list after for admission. Just to come up for admission.
Yes, my lords. 22nd, there is a garnishee order, my lords. That's one.
List on maybe. Yes, list on a new date for admission. before
Okay,
that.
my lords. 22nd may be given. 23rd, it is a little difficulty is there, my lords.
22nd.
22nd. Much obliged, my lord.
They sought an adjournment. Yes.
After one matter. Till number 5, Prakash Shetty, yes.
Cooperative Societies Act. Yes. Cooperative Societies.
Corporate societies.
The serial number?
Well, serial number 5. But the order of the learned single judge, not in fact the lordship will get it at page 17.
Yes.
Not the, so far as I don't, not my submission is, no, I am not saying that the order of the learned single judge is wrong. I have not judged, but only non-consideration of the prayer 2 and 3. Lord, I am before your lordships. But the other prayers has been considered pass an order. I am not aggrieved. The Lord, what has happened? My Lord, another aspect was when the matter came up before this honorable court for admission, I said, so far as the election has been taken place, I am not interested to seek the set aside of the elections because already they took a charge. I am not challenging the election also.
Therefore, that was your prayer too.
Prayer. That, my Lord, my
To become infructuous.
yes, but my prayer is not the deemed approval of the bylaw, the resolution, unanimous resolution passed by the general body has been kept pending for the 8-9 months. Therefore, my Lord, it is a deemed approval.
So
Because
that cannot be anymore because that election has
yes, but
already.
election is when I am not, because as your lordship, nobody, your lordship or a single judge will not set aside the election.
Second prayer is infructuous.
Yes.
Third prayer.
Please, my lords.
Again, quash annexure D.
D.
1310 was with declare with bylaw, so also was with anybody
Yeah.
is deemed approved.
D.
That is all that remains now.
Please,
Deemed
my lord.
approval
Yes,
of the
yes.
bylaw.
Yes, my lord,
Yes.
please.
No.
In fact, my lord, in another bench, your lordship hear it for some time of this matter.
Just a minute.
Yes, anyway.
Yes.
My lord, the general body, my lord, the meeting notice has been issued at page 38. It is on 7/12/2020. I'll, because I'll come to the English translation copy before you, because that is page 38 is Kannada version. Your lordship will get it at page, the 48 is English version.
48.
Please, my lord, the annexure A, the translated copy I have produced, that the relevant is page 48. That the notice of the annual general body meeting is on 7/12/2020
Just a moment. Notice is on 7/12.
Please, yes, my lord.
When was the general body proposed to be conducted?
That is, my lord, on 23rd, 2020.
Was this notice properly circulated?
That your lordship may kindly see the meeting notice. Your lordship will get it at page 50 regarding amendment of the page 50 at item number 10.
Was it properly circulated, Council?
Yes.
What is the finding? Is it properly circulated? If it is not
It-
properly circulated,
My lord,
it cannot be relied on.
my lord, it is properly circulated and nobody raised a dispute that factual, the receiving of them is, nobody have disputed it. I'm sorry, my lord, I am
There is no question of anybody raising dispute. It's a statutory requirement. If the statutory requirement is
Yes.
not complied with,
Ye-
the
ye-
notice itself.
I
is
follow.
sufficed.
My lord, the statutory period is 15 days from the date of the issue of notice. It is on the 7/12/20 notice has been issued and amendment of the bylaw has been communicated. Then, my lord, the general body was held on 28/12/19/2020. General body unanimously approved the bylaw. That is, your lordship, is annexure B. But that has been on 23/12/2020, the by resolution, that has been forwarded to the joint register of the cooperative society at page 51, annexure B, the resolution. That your lordship will get it at page 54 is Kannada version. The English version, your lordship will get it at page 59. My lord, this proposed amendment, my lord, that was earlier, there were 15 directors. My lord, in view of the amendment of the Karnataka Cooperative Societies Act, my lord, if the society is beyond the taluk and within the district, there will be a 17 directors has made a provision has been made by the Karnataka Cooperative Societies Act under section 28 2B. That, my lord, that has been followed and we passed a resolution. Then, my lord, this was, they said the present there are 15, your lordship will get page 59 at the bylaw number 23. English version. Kannada version is lordship is 54 because sometimes 54 is Kannada version is also. English version, the page. Then, my lord, they said in the present there are 15 governing council members according to the Cooperative Society Act. There is a provision for 17 governing council members in the governing council meeting. This decision has to be taken to increase your post. Then, my lord, this is the after discussion. Then the unanimous resolution has been passed for making a 17. Then, my lord, this has been forwarded to the joint register, communicated to on 28/1/2021.
28/1/2022.
28 January 2021, my lords.
Cannot be January 21. It is approved only in December 21. How can it be
No,
January
not
20?
December 20, my lord. I'm sorry. It is not the 23 December 2020, my lord. I'm sorry. Your lordship, may and that your lordship will say.
Done.
I think, my lord, that your lordship will get it at page 56. General body union held on that subject. I'll raise this.
21 is the date stated.
Lord, that is 23/12/2020, my lord. I think if I made a mistake, my lord, I'll correct.
Yes.
Yes.
That is 7/12/20. Yes. It's
Then, my lord,
7/12/20.
your lordship will at page 63 annexure C. My lord, on 23/3/2021, the joint register says you have to produce some more document. That is the English version, your lordship will get it at that page 64. They asked to give then, my lord, The annexure D was the order passed by him, my lord, on 13/10/2021. My lord,
Just one
after,
moment. Just one moment. The difficulty is this.
I'm sorry.
You issue a notice on 7/12/2020 for a general body meeting. Your notice is at page, the translated copy is at page 48. Correct?
All right,
What is the agenda
48.
for the notice?
The agenda.
Agenda.
Yeah, my lord, yes, your lordship says. My lord, the agenda started from the last prayer and welcome to, your lordship, I got it.
There is no agenda for amendment of the bylaws.
My lord,
Of that you cannot amend the
yeah,
bylaws.
there is no agenda, my lord, your lordship is right, I am out of the court.
That
Then
is
your
what?
lordship may kindly have a look at it, page 50, serial number 10.
Regarding amendment of presently existing bylaws.
Bylaw. Not the increase of.
And what is the amendment sought to be made also? There in the notice. Yes, please tell us what is the provision, how are amendments to be carried out? What is the provision in the act?
Yes,
What
ma'am.
is the provision in the rules?
Yes, but the why I have amended it, the Karnataka Cooperative Societies Acts were amended.
Council, that now has been done.
That,
The registrar held that even if you don't amend, it has to be done and it has been given effect to also. That is not the question. You want it to be amended in the manner that the general body proposed.
yes, that is.
Well and good. If a general body is properly conducted
Yes.
in accordance with the provisions of the act
Yes,
and the rules,
yes,
then the general body notification has to be taken into account for the bylaw amendment.
Yes.
Now show us what is the provision in the act and the rules for amending the bylaws.
Yes,
Please
yes.
take us to it.
Well, that is.
That is the difficulty.
I follow.
Been done.
Yeah, I follow, my lord. I'll place it.
Yes.
That is section, the 12, my lord, the
Yes.
amendment of bylaw of the Cooperative
Correct.
Society.
Yes,
Section 12
yes.
of the Cooperative Societies Act.
Yes, please read section 12.
Yes, my lord. One, the amendment of bylaws of the Cooperative Society. A cooperative society may amend its bylaw in conformity with the provisions of this act and the rules made thereunder from time to time, provided that every cooperative society shall make amendment to its bylaw in conformity with the amendments made to this act or the rules from time to time within 90 days from the date of the coming into force of the said amendments. The proposal of such amendment shall be accompanied by such fees as may be prescribed, and different fees may be prescribed to different class or the classes of the cooperative societies.
Stop there.
Yes. Then, my lord, your lordship may kindly 2A.
Rule 6.
That, yes. That is 15 days gap is required. That is the, I follow. I'll go. I'll read it, my lord.
Please read rule 6.
Please, my lord. The 6(2). Yes, but the mayor, the reference 6,
Yes.
the 6(1) is where a cooperative society proposes to amend its bylaws. No such amendments shall be made. The save by a resolution passed by the two-thirds majority of the members present and voting at a general body meeting of the society.
Yes.
No such resolution shall be valid unless notice of the clear 15 days to the text of the existing bylaws and text of the proposed amendment and the reason thereof has been given to the members of the society in accordance with the bylaws. Then in every case, every case in which society proposed to amend its bylaws, an application shall be made to the registrar together with the copy of the resolution referred to in subsection Subrule 1.
Shall we pause there? Shall we pause there only for want of time? Now, please show us that this notice as provided under Rule 6(2)
Yes.
has been given. No such resolution shall be valid unless notice of clear 15 days with,
Yes,
with
yes,
the text of the existing bylaw,
yes, yes,
the text of the proposed amendment,
yes,
and reasons therefore
yes,
has been given to the members.
yes,
Therefore, the notice must contain, it must
Yes.
give 15 days clear notice.
yes,
It must contain the
Yes.
text of the existing bylaw
yes.
and the
The proposed
proposed
bylaw,
amendment.
yes. Then we have placed it before them.
You
We,
show us the notice you're showing us.
that is the only, that is a notice, then it was attached, then we have placed it.
It cannot be. Unless that is there along with the notice, you are not complying with the procedure, therefore your appeal cannot be considered. Now
But that has not been disputed by anybody, any member have not.
to be a
Well,
dispute.
I think the what I have to place is by the resolution I have to place before them under section, under the 6(2).
The existing bylaw and proposed bylaw is enclosed.
Enclosed.
We have given it after. But after they have seen it, they have but that has been discussed in a general body. The notice given to them has been discussed in a general body in detail.
No,
That discuss.
counsel. It is a statutory requirement. It will
Your
not.
Lordship may kindly,
Yes,
I
sorry.
think, I will only take 1 minute for the resolution, that discussion taken place in the general body.
That will not do. In the absence of, it shall not be valid is what the rule says.
I'll mention it.
Amount-
I'll mention it, why he has rejected the amendment. I'll kindly bear with one sentence, I'll take it. After the general body election, he appointed he superseded the board of director. Then, my lord, he himself, the joint registrar himself made an amendment to suit his convenience without the approval of the general body. He made, that was annexure H. Because, my lord, he want to do it for extraneous reasons. But the annexure H, my lord, without any, ours has been rejected it. He himself made the amendment of the bylaw. Then, my lord, he has no power.
Yes, we understand the contention, but we are unable to help you because the provision is clear. If you had complied with the provisions in the notice and had conducted the general body, you probably would have had a case. But you did not. This is your notice that you have produced.
Along with that notice, my lord, we have given the proposed bylaw that has been given it, my lord, that is it.
Yes.
That has not been disputed factually. Anyway, I'll.
Yes, heard the learned counsel for the appellant. Quite an extensive. Full stop. The learned counsel for the appellant submits that with regard to the first and second relief sought for in the petition, the appellant.
My lord, may I make one submission with save the time of your lordship. I will withdraw it with the liberty to move it, because why should I take? I follow, therefore I withdrawing it
Yes.
to save your some time.
Learned counsel for the appellant seeks liberty to.
Liberty reserved, because then we have a right to, in a general body, then we can do that. Liberty reserved with a.
Appeal is rejected,
Yes, withdrawn.
is dismissed as withdrawn.
Please, Leonard, much thanks.
Leaving open legal contentions, if any.
Number 14, the C. Babu.
Yes. It is your appeal.
Both appeal.
Both appeal. Cross objection is also there. Yes, yes.
B6 now, 900 rupees.
The preliminary notification is on.
File code.
18/1/2007. Final on 16/2/2009. Land is extent
17 guntas. 17 guntas.
converted land. What is the purpose of the acquisition? Railway line. You have seen them. It is 250 is reduced to 200. It's already there, no? See, it is here. We have a copy. Where is the respondent? Where is the cross objector?
Lord, the judgment which, Lord, on the basis of which the judgment was passed, what was passed. Lord, it comes only rupees 132 rupees. This is higher than what is there.
Hear him pass over once more after 2:30 or whenever he comes.
Just inform him. If does not come also, we pass the orders. Pass it. First, we take note of that. Say that 2016 notification. We cannot. Final hearing.
For final hearing, December 37 adjourn, December 38. TP Chinnappa.
No, I appear not for the appellants in this case.
Yes.
There are, my lord, two appeals and one cross objection.
Yes.
I am the plaintiff in one case and the defendant in the other case. Lord, there is
There were two suits.
yes, my lord, there were two suits. One suit was for specific performance by me. That is, my lord, OS number 1696 of 96.
Yes.
The prayer, my lord, was to direct the defendant to execute sale deed as per agreement dated 6/2/75. The other suit, my lord, was filed by the first defendant's children in OS number 5955 of 96. The prayer there was for partition and 2/3 share, and also for a declaration that the lease deed executed by the father is unenforceable, and for a direction to that is a defendant in that suit, to vacate and give possession. They also sought accounts and mean profits. But my suit was been dismissed.
Yes.
And the suit filed by the the counter suit has been decreed in part, but not giving possession. Therefore, my lord, they are in cross appeal, cross objection number 5 of 2011. My lord, there is a family tree which is marked as exhibit P41.
Yes.
It is, my lord, there are two paper books.
Yes.
The lordships could take, my lord, the additional paper book.
Yes.
I'm afraid, my lord, I noticed that is missing in that. So I think my colleague, my lord, has got some printouts which she can hand over, or your lordships that will take the trouble of looking at the trial court record. Just to show the relationship of the parties,
Yes. Printouts are available with regard to the family tree, please.
We're just pulling out the trial court records.
I may not, just to save time, proceed by just narrating the
Please,
relationship and
please,
continue.
please.
So that your lordship may not wait for that. My lord,
Yes.
the relationships are like this, my lord. There's a famous, my lord, Diwan of Mysore state, Diwan K. Sheshadri Iyer.
Hmm.
The lordships may see a red library building in the middle of
Yes.
Common Park that is named
Yes.
after Diwan Sheshadri Iyer.
Yes.
Now, the dispute arises from one of his sons, his branch. One son was called Krishna Iyer.
Yes.
And Krishna Iyer, my lord, had 6 children. Out of that, my lord, 7 children actually, 2 sons of his.
Yes.
K. Sheshadri and D.K. Sheshadri. Their children, my lord, are the warring parties.
Yes.
So in other words, my lord, Mr. K. Sheshadri's son Ashok,
Yes.
he is the elder cousin.
Yes.
Mr. D.K. Sheshadri's son, who is K.D. Sheshadri, is the younger cousin.
Yes.
This K.D. Sheshadri, my lord, was living in Bombay.
Hmm.
He was not married, my lord, for a fairly long time. Rather late in age only he got married.
Hmm.
Before his marriage, he was not interested in keeping these properties.
Hmm.
Therefore, my lord, he entered into a registered lease
Hmm.
on 6/2/1975 with a covenant giving an option to the lessee to purchase the property for a sum of rupees 1 lakh.
Hmm.
The property, my lord, is in the old part of the city in Malleshwaram area.
Hmm.
Which today, my lord, is a very prime property.
Hmm.
It measures, my lord, 82 by 104 feet, approximately 8,528 square feet.
Hmm.
Now, the lease deed also said, put a condition that this lessee shall spend his own money and put a construction.
Hmm.
So he constructed the house in 1974-75
Hmm.
and built a house, and he was living there. Unfortunately, he is now not in this world to see the end of the litigation, but his sons, my lord, are before the court. The case, my lord, made out was that the lease was, he actually wanted to sell the property,
Hmm.
but then he had some tax issues. My lord, he was doing some construction business. And so when he said, if I sell the property, I'm going to be incurring a huge capital gain. Therefore, we'll enter this agreement. You pay me whatever has to be paid. And, when my situation improves, I will enter into a sale deed and, formalize the transaction. That was the understanding. I'll read the lease deed in due course. And at that point of time when this lease was entered into, the plaintiff, his sons, my lord, were not born. He, my lord, the 2 sons were born on 24/5/1982 and 22/5/1983. So they are the ones, my lord, who filed the partition suit in 1996.
Hmm.
The date, my lord, of the suit is 24/8/96. Before filing of the suit, there has been some correspondence. And this gentleman, my lord, my cousin, the first defendant there, he got married in 1981. So it is about 6 to 7 years after the lease deed. So the children were not born at that time.
Yes.
My lord, the narration of facts would go to show that all payments were made. There are receipts that were issued also. I'll show your lordships for that documentation. Meanwhile, my lord, a draft of a sale deed was prepared. And the draft of the sale deed was seen
Yes.
But he could not come and execute the document. One other slight twist in the case, my lord, is that since he was away in Bombay and he could not physically come, he, my lord, gave a power of attorney in favor of another cousin of theirs, one Mr. J.R. Sheshadri. All Sheshadris, my lord, it took me considerable time to sort of demystify the Sheshadris.
Yes. Yes.
So, this J.R. Sheshadri, there is a power of attorney executed in his favor. That's not in dispute. And the power of attorney contains explicit power to deal with the property, enter into agreements, sell the property, grant lease, all the powers are available. And that power of attorney was never cancelled, nor was any notice issued. But the draft of the lease deed, my lord, this whole thing may not be of much significance, because when the lease deed was prepared and the draft was circulated as per P29, the defendant himself, my lord, sees it, initials it, he says, okay, seen, and signs it. But the actual document is not signed by him, it is signed by his power of attorney holder. Now, the trial court, my lord, construes that this covenant in the lease deed to sell the property is not legal. Therefore, my lord, the court says I cannot grant specific performance. And also there is some doubt they try to show on when the monies were paid. There are documentation, I presently show your lordships that. And according to us, I paid the entire part of the consideration. Now, the court holds that no, this is not proved and this covenant in the lease deed cannot be accepted. And therefore, my suit for specific performance, my lord, is not considered. Meanwhile, the court does not consider the fact that I have acted in terms of that covenant. I have been put in possession. As a monthly annual rent of 100 rupees was payable per month. That also has been paid. There are receipts for all of that. And the court says that the transaction cannot be given effect to. So far as the suit of one of the contentions I raised, my lord, was this. It is not their case that this was a property which was ancestral or had HUF character. Even if it was so, before the marriage and the children were born, if he is assumed to be the Karta, he has executed a document in favor of a third party and received valuable consideration, can the children born subsequently challenge this action? Is also another point, my lord, which will arise. And one other contention, my lord, they say is that this lease deed was a fraudulent transaction. One of the grounds for that is that the lease deed also includes not only the first appellant, Dr. Ashok, but it also included his minor son, Arvind. So in the lease deed, we have both the names. So one of the contentions they urge is that this lease deed is void because there was a minor in it. My lord, the law seems to be very well settled, my lord, in Mohri Deep BB versus Dharmadas Ghosh in about 200 years ago or so, where a minor can always be the beneficiary of a contract, and a contract with a minor is not void, it is voidable at his option when he assumes majority. That's the law. But nevertheless, they take the stand that the agreement, the lease agreement is not a valid document because of this reason. And I also pleaded section 53A to the Transfer of Property Act. And that also, my lord, is not been considered by the court. So far as the fraud is concerned, there's no other evidence, no other specific government as to what was fraudulent, nor is there any evidence to show that the value of the property, my lord, we are going back to the 1970s. My lord, in 70s, Bangalore was, I would say, a slightly small town, glorified village. And from one end of the city to the other end, we could easily go in less than 15 minutes. I used to cycle across the city, my lord, in 10 minutes to school and college and back. So that was how Bangalore was. And Malleshwaram was one of the old extensions where a lot of landed gentry, my lord, stayed there. And so houses of about 8,000, 10,000 square feet is commonplace. It was not something, like a Maharaja's place. Nobody considered it to be so. And so those were the times. And at that time, my lord, the consideration agreed was 1 lakh. So, my lord, it is a very,
some according to you.
it's a very, very, yes, my lord. I know of transactions in the Sadashinagar and other areas in the late 60s and 70s, where 80 by 120 site was available for 25 to 30,000 rupees. And that was a newer extension. Malleshwaram being slightly older, many people thought that that was a more better place to live in, because it had formed roads and they had a conservancy lane in the houses. So it did carry a premium at that time. So if you look at it from that point of view, it's a very substantial sum. And the point that arises for the Honorable Court, my lord, is this: whether the denial of my right under this agreement would be just and lawful, or whether there were any grounds to deny specific performance to me. Now, my lord, could your lordships take the paper book? I'll my lord, try to draw your lordship's kind attention to some documents. The first document, my lord, is I think it's paper book.
The original paper book.
Yeah, I'm told, my lord, that there are two paper books. One
The additional paper book starts with the plaint in
Yes.
599,
Yes.
5955.
Yes,
That is
kindly
the-
take that, my lord. At page 39,
Yes,
the exhibit P1,
yes. Exhibit P1. Lease deed dated 6/2/75,
yes, ma'am.
page 39.
Yeah, I think, my lord, page 39 is. Just a moment. Your lordship has 39, my lord.
Yes.
This is a typed copy.
Yes.
This indenture of lease made on the 6th of February 1975 between Kumar Doreswamy Sheshadri, that is K.D. Sheshadri,
Yes.
age so-and-so, son of D.K. Sheshadri, residing at so-and-so, Bangalore, represented by J.R. Sheshadri, residing at so-and-so. This is the same address may be noted, my lord.
Yes.
Power of attorney holder. Executed, the power of attorney is dated 9th December 74. Executed by the lessor, authenticated by the sub-registrar. And Dr. K.S. Ashok, he is not the appellant in my appeal. Age 46 years, son of late Sheshadri Iyer and Arvind Ashok Sheshadri, age 11 years. Minor represented by his father and natural guardian, both residing at Kumar Krupa Road, so. Then on page 40, there is a recital regarding ownership. SR is the owner of the plot, measuring 3845 square yards, situated at 7, 12th Cross, 6th Main, Malleshwaram. Then the lessees, being desirous of constructing a bungalow for their residence on a portion of the said land, approached and requested lessor in October 1973 to grant them lease of a portion of measuring 947 square yards or thereabouts on the southwestern corner of the said land, together with workers' shed and well, marked in green hatched lines on the plan hereto annexed and described in Schedule 2, hereinafter referred to as the scheduled premises, for a term of 98 years, commencing from 1st November 73, with an option reserved to the lessees to buy the aforesaid portion of the said land, together with workers' shop and well, for a sum of rupees 1 lakh, and paying therefore a monthly rent of 100 rupees, the lessees having paid the lessors a sum of 25,000 on 1/11/78, further sum of 25,000 paid on this day. In all, 50,000 as interest-free deposit. The lessor, who is the cousin of the first lessee, agreed at this request, though the market value of scheduled property was assessed as wealth tax value as 1,20,000, in consideration of the lessor's natural love and affection of the lessees, and in consideration of the rent hereby reserved, and the deposit of 50,000 made by the lessees. The lessees, being anxious to commence construction of the bungalow in order to have same ready for occupation at the end of March 75, requested lessor to have necessary plans and blueprints prepared and also apply for obtain requisite license from municipal corporation. The lessor has complied with the request. At their cost and expenses, lessees have commenced the construction with permission of the lessor. The lessor and lessees were unable to execute lease deed incorporating all terms and conditions of the lease till this day, and the lessor and the lessees have mutually agreed that this lease should be deemed to have commenced from 1st November 73 on the date on which lessees were put in possession of the scheduled land, together with workers, shed and well, on which they have commenced construction at their own cost and expense, the lessor having obtained necessary licenses and permissions on behalf of and at the expense of the lessees. Then, my lord, next is about covenants, etc. I'll not read the formal part of the documentation. Lord. Page 43,
Yes.
para A. Lessees shall pay during the term of the lessor monthly rent of 100 rupees as hereinafter reserved at the time hereinbefore appointed payment respect to the scheduled property. Then the lessees shall bear and pay. This is important. No? Municipal and urban immovable property tax. Normally, this is not a condition in the lease. The lessor will pay it. And all other rents, cesses, rates, taxes, etc. outgoings, ground rent, assessments, whichever are payable and which may be levied hereafter and become payable in respect of demise premises and structures thereon, whether built by the lessor or lessees, that all rents, taxes, rates, cesses, assessments, ground rent or charges and outgoings, which may hereinafter be levied by the government or statutory enactment by any body, public or authority by way of rents, charges, etc., or otherwise howsoever and whatsoever shall be payable by the lessees, and all other payments also to be paid. Then, my lord, one more important condition is that I must put up the building. It's not that I can just leave it like that. Clause C in the next page. The lessees under all circumstances within 36 months from the date hereof at their own cost in all respects and in substantial manner in compliance with the statutory and local regulations applicable thereto, construct on the scheduled premises and cover and complete with all fixtures for occupation a building of permanent nature as per plan and specifications approved and certified by the lessor's engineers, expending on the aforementioned building or buildings a sum of rupees 2 lakhs. Provided, that if the lessee shall be prevented from completing the said building or buildings within a aforesaid period owing to labor strike or statutory ban on obtaining building material, then reasonable time shall be given to the lessees for completing the said building. So this is also a very unusual term. Lease is given asking the lessee to put up a structure, and the lessor obtains the plan. Lessee will put up the building, and the cost is also mentioned 2 lakhs, which is again a lot, a very, very substantial sum at that time. Then D is that they will construct the building according to the sanctioned plan. Then next page, 46.
Yes.
The boundary wall G, my lord. The lessee shall pay a reasonable proportion of the expenses for the repaint and maintenance of all party walls, party fences, walls or fences, sewers, drain pipes, water courses, and other easements used or to be used in common by the owners of that premises. As your lordship saw earlier, my lord, the area owned was a substantially larger portion, 3,845 square yards. Your lordship get it at page 40.
Yes.
Out of that, 947 only is to be given.
Yes.
So there's a bifurcation wall and fences and all the underground pipes, sewers, etc. had to be done. So they're making it clear that your portion, you're enjoying it, but you must bear a proportion of this also. Then clause H is a usual indemnity clause in the case of any construction, in the case of injury, etc. Then I, the lessees shall, on the expiration or sooner determination of the term hereby granted, deliver up the structure of the demise premises to the lessor, provided the lessor pays to the lessee for the structures erected to lessee on the scheduled land at the prevailing market rate, in any event not less than 2 lakhs. Then this is important. The lessees shall have been required to do so by the lessor. The lessees have deposited with the lessor a sum of rupees 50,000 only to be held by the lessor as a deposit, which shall not carry interest. The said deposit shall be returned by the lessor to the lessee on the determination of this lease, and in the event of the lessees exercising the option reserved to them hereinafter to buy the demise premises from the lessor, this sum shall be adjusted towards the agreed consideration of rupees 1 lakh only for the absolute sale of the scheduled premises to the lessor. The lessor shall pay the fees of the lawyers, etc., etc. Then lessor's covenants, lessee's covenants. Lessor's covenants is that normal covenants that lessee will have a right to enjoy it. Then at page 49 and in 48, it provides for re-entry. provided always, and it is hereby agreed, that if and whatever, whenever, any part of the rent hereby reserved shall be in arrears, whether the same shall have been regularly, legally, or formally demanded or not, covenants or stipulations on the part of lessees or their permitted assigns herein contained, on the lessees or permitted assigns failing to pay arrears of rent or remedy breach or breaches of any covenant and conditions, within 12 months from the receipt of notice from the lessor calling upon lessees or their permitted assigns to pay the arrears of rent or breach of any covenant, the lessor may re-enter upon scheduled premises any part thereof in the name and whole thereof immediately, and all the rights and lessees and assigns shall cease to be determined. In case of such determination, re-entry, scheduled land with building and structure standing thereon shall absolutely belong to and vest in the lessor, subject to payment of market value of the structures erected by the lessee in the scheduled land, which sum shall not even exceed 2 lakhs. My lord, only one thing I request the Honorable Court to note here is that normally, my lord, the re-entry provision is linked to many of the other covenants in the lease. Here, it is linked only to rent.
Non-payment of rent.
Non-payment of rent. No other covenant is there. Supposing I don't build the house, then can he terminate? That is not there, only for non-payment of rent. Then what? Page 49, clause 5. It's also hereby further agreed and declared that if the lessees at any time during the terms of this lease desire to purchase the scheduled premises, the lessor shall sell to the lessees the scheduled premises for a price of 1 lakh, and the deposit of 50,000 only herein paid shall be treated as part of the consideration for such sale. Then notices, etc. This formal schedule is describing the property. Now, my lord, your lordships may have to kindly take Exhibit E29 in the trial court record, my lord, because that initials are not forthcoming in the typed copy that has been filed. Exhibit P30, where the initials are found. It should be in the trial court records at page, my lord, I don't know if the trial court records are paginated. They're supposed to do it, but I'm not sure. It's a draft.
Yes.
Right
So
on top.
P30.
Yes, P30, my lord. On top, left side,
Okay.
the lords will find okay, and there's an initial.
28/12/74.
Yes. That is, my lord, about 8 or 9 months before the actual grant of the lease. Something will turn on this because this was shown to him and he also admits that it is theirs. There's no dispute on that.
Yes.
Then, my lord, if I can go back to the paper book, at page 106 is the power of attorney hold.
One zero six.
106, exhibit P29. This is in the paper book. To all whom these presents shall come, I, Kumar Doreswamy Sheshadri, son of late D.K. Sheshadri, send greetings, that I am the owner of the property more particularly described schedule. Whereas being unable to attend personally in Bangalore, I am desirous of constituting, nominating, appointing Sri Jaishil Rajan Sheshadri, son of Krishnaya Tyagaraja Rajan, to be my true and lawful attorney. Know all men by these presents that I, Kumar Doreswamy Sheshadri, son of D.K. Sheshadri, age 40 years, hereby nominate, constitute, and appoint Sri Jaishil Rajan Sheshadri at number 7, 13th Cross, 6th Main, Malleshwaram, Bangalore. It's the same address. He used to live there only. As my true and lawful attorney, to set on my behalf and in my name and to do and execute all or any of the acts or things hereinafter mentioned. That is to say, I'll skip over not. Point 3. 1, 2 is to pay taxes, etc. 3 is to lease. Then, my lord, 4 to file suits, 5 architects, 6 cement, etc. 7, my lord, is for sale. Negotiate, fix the price, sell or lease the lands and buildings in one lot or separately upon such terms and conditions that he may deem fit, receive the sale proceeds or lease rent and give effectual receipts thereof, and to execute and sign such deal deeds or lease deeds and get them registered for their purposes. Then appear before sub-registrar and manage all my properties, etc.
Yes.
The document which your lordship saw from the original record is in the next page, P30, and your lordship's noticed, my lord, that it was, the initials were there. That initial is marked, my lord, as P30A. Now, my lord, there was another suit in relation to another issue in which, my lord, there is a certain admission. If your lordship, please go to page 150. The same defendant
Yes.
was, my lord, examined as a witness in another case relating to another property, which is OS 3730, page 150. And the date of this deposition is 3/7/2002. Your lordships will get it right at the end. But at 150, this is the deposition of this defendant, the lessor, in another suit. I do not know the plaintiff in the case. I have never seen plaintiff. Defendant 2 is J.R. CH-3, my cousin brother. Now, that was another suit filed by somebody else relating to another agreement. And the agent was also made a defendant in that case. So in that suit, this principal is giving evidence. I do not know his whereabouts. I know one KV Jairam. I came in contact with him in connection with property bearing number 7/4, Malleshwaram. I came in contact during 82. Said Jairam approached me in connection with the said property. Said Jairam met me at Madras and discussed with me for the sale of the plot. After negotiation, I agreed to sell the said plot in favor of Jairam. There is an agreement between me and Jairam in that connection. 4482, Jairam paid an advance of 1,000 by check, drawn and so and so. He paid me a further advance. My lord, lower down he says there about agreement, my lord. I have executed a registered sale deed in the name of J. Ramesh in respect property. Property sold is measuring 100 by 50. I have sold the property for 2,65,000. Defendant 2 never take part in negotiations property. Then next para, my lord, is not relevant for us. Please go to para number 4.
Yes.
I have executed a GPA in favor of defendant number 2. That is this J.R. Sheshadri.
Yes.
In the year 74, in connection with property bearing number 7/1.
Yes.
During the year 74, part of the property was leased to one Ashok. In that connection, I have executed power attorney in favor of defendant 2 to execute the lease deed as unable to come over to Bangalore from Bombay. I have executed said power attorney in the office of Sub-Registrar, Bombay. At the time of execution of the power attorney, defendant 2 was present at Bombay. I sent the said power attorney to Dr. Ashok to get the lease deed registered from defendant 2 in his favor. I instructed Ashok to retain the said power attorney with him after getting executed the registered lease deed in his favor, as the said power attorney was executed only for the purpose of defendant 2 has not acted. KV Jairam in respect to suitable property. After I executed an agreement in favor of the suit property, then he goes to the rest of it, my lord. At page 154, last penultimate sentence of this cross-examination. Hence, I pray to this court to dismiss the suit filed by the plaintiff with cost. Defendant number 2 has no authority to sell the property bearing 7/3 in favor of plaintiff. So it's very clear and categorical. In so far as 7/1, he maintains that it was him who did it, how the document was executed, why it was executed, everything. But this Jairam suit relates to 7/3.
Yes.
And for that, the author says that it was not meant for him at all. Therefore, it could not have been given. The cross-examination in that case is also produced, my lord, but your lordships may go to just a few sentences at page 166.
And 60 also, he says, I have confirmed power to defendant. to deal with property in its entirety.
Yes.
P6 does not restrict the power of attorney to execute document only in favor of Dr. Ashok. Then since 1983, Dr. Ashok continued to stay in the same address at Malleshwaram, which is part of my property. After coming to know the fact from earlier suit, second defendant has executed an agreement of sale in favor of plaintiff by receiving so and so. On my inquiry, second defendant denied having executed such an agreement.
The plaintiff there was challenging another document. So, but in the context of that, he may not very clearly and categorically, not one place, but he reiterates again and again. Then there's not a cross-examination about bifurcation, etc. Not.
Yes.
But please go to page 166.
Yes.
Again, this power of attorney, my lord, comes.
Yes.
About fourth line. Since the power of attorney was executed in context to execute sale deed in favor of Dr. Ashok, so now he is referring to sale deed. As such, I did not admit power of attorney in the written statement filed by me in the earlier suit in respect to suit property. I had executed power of attorney in 74 during the year 1996. Dr. Ashok filed a suit against me and my son. Since the power of attorney was related to execute the deed in favor of Dr. Ashok, as such, I had not taken any steps to revoke or cancel the power of attorney, and the power of attorney was not to the public knowledge. In spite of presence of clause number 7 in P6, the above stated my answer holds good. Second defendant has not appeared in the suit on the dates when I appeared before the court. I did not ascertain through my advocate or from court records to know whether the second defendant had appeared in the earlier suit on this suit. I did not encourage second defendant for return of the advance amount, etc. This evidence, my lord, what your lordships are now seeing, it begins, my lord, at page 150. That's what your lordship saw just now.
This is in OS number 3730 of 1986.
86.
And when is the deposition given? Date?
3/7/2002.
2002.
Yes. 3/7/2002. Your lordships get the date at page 154. And then the cross-examination from 155 onward, not dates there.
Yes.
1802.
Yes.
Then it continues, my lord, at page 159. 27/8/02. I think your ladyship just now noticed page 161, my lord.
Yes. Yes.
Then it continues in Kannada on 10/1/2003 at page 169. Now, my lord, I come to the payments that were made.
Yes.
What is the evidence to show that payment? My lord, one more factor is that after the building was built, the building was assessed in the name of our client, not in the name of the lessor. I have produced municipal records, my lord, which shows that. At page 52 in the paper book, exhibit P2. This is a special notice issued by the revenue.
Yes.
With reference to the application of 20th August 75, requesting transfer of Kata, Dr. K.S. Ashok is hereby informed that bifurcation and transfer of Kata are approved with effect from 1/10/75. Same is as follows. The superstructure put up on the vacant land measuring 104/82 leased in favor of K.S. Ashok is allotted new municipal number 7/1A, assessed at annual value of so and so, with property tax of so and so. Kata of this portion only for the superstructure registered in the name of K.S. Ashok. Vacant land measuring 104/82 leased to Dr. Ashok on a monthly lease of ₹100 is allotted new number 7/1, 12th cross so and so, and assessment is given. Kata is in the name of Sri K.D. CH-3.
Yes.
Then, my lord, payment of tax, etc. Also, I have produced the documents at P4 onwards.
Yes.
At the payment of this 25,000, my lord, is evidenced at page number 56. There were two payments of 25,000, which were referred to, my lord. The passbook at page 56 indicates the payments. On 18th of March,
Yes, yes, 18th.
payments are there,
And 19th of March.
19th also. Thereafter, Lord, some further payments were made towards rent at page 61. Last entry, November 18th, 5,000 rupees. At page 61, my lord, we don't get the year. Should be in 77. But the next page, your lordships will get the year at page 62. May 7th, 1977. 100 rupees, my lord, per month was the rent. 3,500 is paid. P5 at page 64 also. April 13th, another 5,000 is paid. And rent receipts are also issued.
Yes.
Not the typed copy is in the paper book P10, but the trial court record will have the signed versions.
Yes.
12/12/81. For the year wise, he has given a lot of receipts. 77, 78, 78, 79. At page 68 is 79, 80, then 80, 81.
Yes.
Now, they try to overcome this by saying that these were all fudged. These are not their receipts. Then we got P60, page 69, P11. The agent is also confirming these payments.
EA holder. Yes.
At page 70, also, there is a detailed statement. Then P13 is also another statement. P14, P15, and P16, my lord, is a confirmation from him. Now they try to overcome this also to say this is also not a genuine document. P16 showing full payment of 1 lakh have been made. All the details are there, and these details are supported by bank entries. A few cash payments are there for which there are receipts. At the bottom of page 75, I, KD CH-3, confirm that I received a total sum rupees 1 lakh as above from KS Ashok and Arvind Ashok, being the total consideration value of the property leased to them towards sale at their option. 12/12/81.
Yes.
Then not page 76 is P17. There's a letter in which also, my lord, he is reiterating what is there in the receipt. It doesn't bear a date. The handwritten portion, my lord, will show the signature which is in the trial court record also. It says, my dear Ashok, as per lease deed dated 6 February 75, a sum of 50,000 was to be kept as interest-free deposit with me on account of the above-mentioned plot. It was further agreed between us that I would sell the land, said premises to you at price of 1 lakh. Deposit of 50,000 paid by you would be treated as part of consideration. Since the execution of the lease deed, you have paid me the balance sum of 50,000 also, making the total amount paid by you to me as 1 lakh. I shall execute a conveyance deed for the lease premises in your favor at any time desired by you. I have received all the rents up to date from you. Hence, no lease rent is payable by you now. And if your lordship would care to see the trial court record, my lord, it's a typed letter in which there is the signature of Mr. K.D. Sheshadri. And that is also, my lord, shown to him and exhibited as 17A. Even in the original, my lord, I do not find any particular date mentioned in the document.
The column for date, but not fill.
It's left blank, my lord. On the left-hand side bottom, it says date, but we don't see any entry there. Something very, very faintly there. I don't think there is there, my lord. The Xerox copy, certified copy, I think it is not there.
No date.
Yes.
Yes.
Then one more document, my lord, in 95. This
Are these
95
documents also disputed?
Yes, they dispute en masse everything.
Okay. Yes.
Then my lord, the next piece at page 77, P18.
Yes.
Here, there we find the date. I, K.S. Ashok, residing at so-and-so, do undertake to pay K.D. Sheshadri the claim on account of gift tax or tax on capital gains, if any, on registering the sale deed of lease number so-and-so. I, K.D. Sheshadri, has leased out land of 7/1 on 6 November to me as per registered lease deed. And as per lease deed, I have already exercised the option to purchase the land. Consideration money having been paid in full between 73 and 81. K.D. Sheshadri has agreed to execute the sale deed before the registering authority before 10th November, dated this 8th November 1995. Not why this became necessary was, initially, my lord, he said I have tax issues, so I don't want to register. At some point of time, they discussed it. And my client said, well, if you are going to have a tax liability, I will pay you additionally tax liability. You please finish the formality. This is what, my lord, he gives a letter to this effect. And this is on the basis, my lord, of some advice they took from a chartered accountant, which is a P19 at page 78, my lord, in the paper book. Where the chartered accountant is saying, this is to confirm, I have advised K.S. Ashok to bear the claim, if any, from Sheshadri on account of gift tax or tax on capital gain that may arise on registering the sale deed of lease land number so-and-so in favor of Ashok. I given the above advice to Ashok when they approached me for consultation on 4/11/95 on matters connected with the above property transaction. So they went to a chartered accountant, took the advice, and on the same day, a letter is written. But this certificate, my lord, is dated 2004. 1st January 2004. So there's some criticism to say this seems to be a letter which you got up and things like that. But my submission, lord, is it makes no difference. He is only confirming the chartered accountant that Dr. Ashok had met me and he had taken my advice. And this is what was undertaken. Lord, there's also a draft of a sale deed that was been circulated at P20.
Yes.
Page 79. And on the left, again, if your lordship sees, my lord, in the original from the trial court record, says corrected final draft for typing on stamp paper. Below that, and that is 4/11. 4/11, my lord, the date is the date on which I write saying I'll bear that tax. Top left-hand corner endorsement.
Okay, 511.
On top left, my lord, its handwritten portion reads, corrected final draft for typing on stamp paper, and date is there, 4/11/95. For approval of KDS. Then below that, he says, okay, he signs it on 15/11/95.
511. 1511.
My copy, my lord, I'm reading it as 15/11. I don't know, my lord, your lordship to see the word, but maybe 5/11. In the photocopy, it's either 5 or 15, my lord, I'm not able to exactly make out.
Whatever. Yes.
Looks like 5 only, my lord. It looks
That is
like
also-
5.
Those endorsements are also denied.
Yes.
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 We'll continue, my lord.
We'll continue after lunch.
May I have 1 hour permission, my lord? I'm in a apartheid case in another court. I'll finish in by 3:30. I'll come and wait, my lord. As soon as I
Please,
can.
please.
Great.
Just inform us when you get.
One submission, my lords. Serial number 48, my lords. I appear for appellant, my lords. Kindly have it in the next week, my lords.
Please inform the other side.
Please.
My lord, serial number. My lord, serial number 44, morning I mentioned, my lords, they gave a date 27, some inconvenience to the senior counsel. Can I have it 30th or 31st?
My lord, it's serial number 34, my lord. My apologies, I forgot to make a prayer for extension of interim order.
Which matter?
Serial number 34, man.
Very well.
value of the property as on the 2006, that also they have mentioned. In 2006, sale deed 5,30,000 for 2,400 square feet. That will be 220 rupees, please, madam. For the 10% escalation means 250 rupees that has been calculated and properly orders were passed. The appellant was by me misconceived that they have calculated it as 120, not actually 120. That will be 220, please, madam. 5,30,000. That will be 220. For that, if 10% acceleration is taken, that will be 250. That is properly paused. LAC 25 of 2009. So that need not be interfered for that reason, please, my lord. In fact, as on today, that value of the property is much more than that. Amount was also not deposited immediately, even very 1 year back, that is in the month of May 24, May 24, they have deposited amount, please, madam. So that is one part, please, madam. The other part is that, please, madam, we have filed cross objections, wherein some of the points were not considered by the court below. That has to be considered. You will also may kindly see. Trial court records are there, lost me kindly. In Exhibit P23, please, my lord, the trial court records.
Another copy.
Yes, ma'am. Wherein you also may kindly see that total is land was around 1 acre, 7 guntas. Out of that, 17 guntas were acquired by Railway Department and remaining 30 guntas were acquired by Highway Department. Unfortunately, in this property, one railway track is going, side by highway is also going. His lands have been totally issued with it. So totally how much trees were there earlier and what is actually calculated is been mentioned, please, Mela. In that actually, SW ರೈಲ್ವೆಗೆ ಒಡಪರುವ ಮರಗಳು ಕೆಳಗಡೆ ಇದೆ ಎಕ್ಸಿಬಿಟ್ P23 ನಲ್ಲಿ ಇನ್ಫ್ಯಾಕ್ಟ್ ತೇಗದ ಮರಗಳು ಹಾಗೂ ಇತರೆ ಮರಗಳ ಸಂಖ್ಯೆ 358, ತೇಗದ ಮರಗಳು ಹಾಗೂ ಇತರೆ ಮರಗಳ ಸಂಖ್ಯೆ 201 ಮೌಲ್ಯಮಾಪನ ಮಾಡಿರೋದು, 157 ಮರನ ಮಾಡಿಲ್ಲ. ಫಾರ್ ದಟ್ ಅಮೌಂಟ್ ಎಷ್ಟು ಯಾವುದು in that ಇದರಲ್ಲಿ ಕೆಳಗಡೆ ಫಸ್ಟ್ SW ರೈಲ್ವೆ ಒಳಪಡುವ ಮರಗಳು SW ಅದರಲ್ಲಿ ಟೋಟಲ್ 358 ಇದೆ. ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದು 201ಕ್ಕೆ, ಡಿಫರೆನ್ಸ್ 157. Yeah, the difference is 157, please, madam. Totally, these teak wood trees are 358. They have paid money for 201. For remaining 157 not paid. And the coconut tree 33 totally. They have calculated 15. The remaining 18 has
the age. If it is just planted, you can't have that.
Not just planted. Adana
What is the evidence for that? What is the age of that?
That is there, please.
Yeah, evidence till ತೋರಿಸಬೇಕು.
Yes.
Don't refer the merger what they have drawn. We'll show your evidence.
I may kindly permitted to pass on these photographs.
No, photo ಮೇಲೆ ಹೇಳಕ್ಕಾಗತ್ತೆ. Not in appeal photographs ಬರಲ್ಲ.
ಅಲ್ಲ.
Refer exhibits. What you have produced to show that 153 total trees are there, you are required to pay the compensation for that. Where is the evidence for that?
Exhibit P. This is the only thing I can produce. Mazar, the official.
What you have done, you should show.
No,
References by you.
In fact, when the notification was issued, they have only calculated the lesser number of plants. Then we have filed an application, and thereafter they have come to the place and they have verified, and they have given this opinion that 157 plants have not been taken into consideration.
Is the grounds of appeal, you read there, which is the ground you have stated? But it is teak wood, para 14.
It's just a typographical error, my lord. Because, my lord, LAC 25 of 2009 was relied. My lord, in that judgment, my lord, LAC 28 of 2009 was, my lord, taken into consideration. By my lord, the the extent was my lord 60 into 80. 4,800.
In that case.
In that case, my lord, relying on LAC number 28 of 2009, my lord, 250 was fixed in LAC number 25 of 2009. My lord, in LAC number 28, my lord, the total, the sum is given, my lord, 5 lakh, the sale deed relied upon is 5,30,000. With the extent is 60 into 80.
No, he refers to exhibit P 23, merger, and say that some of the trees.
My lord, the
Yeah, the rounded, it is 220 actually. This is
16 to 40.
It's not 120 but 220 lying on the.
250.
It is not 220, it is 120 itself because the extent of property is 16 to 80. It is not because
16 to 80.
60, 40.
Therefore, if you-
Exactly the calculation.
It is not 20.
It's 120 only, yeah?
120 only.
That is correct then.
Yes, please. If the only, my lord, instead of 80, it is 40 is written. That is the mistake is conducted while preparing this.
110.
110, no?
Only to 110.
I don't think so, please, madam. Okay, that 5,30,000, but why that LAC 25 2009 was come to the conclusion to the effect that will be 220 rupees. For that 10 rupees, 10% has been escalated, and then that will come to 250. That was passed properly. Now my learned friend is saying that 60, instead of 60, 40, 60, 80, he is saying that.
What is 120 take maximum?
Where is the document that has been relied on in that?
The trial,
Value shown is 5,30,000.
yes, my lord.
What is the extent for us to see as to what was the extent? Was that
judge-
document ever produced?
I have, no, we have not produced that copy. Please. Court has relied, we have not produced that document. We have to obtain that certificate copy of that judgment only now. LHC 25 of 2009.
So everything.
If
then
they are
200
ready with,
itself is a more than,
my lord,
200 itself is a more now. Coordinate bench has granted 200.
no, in fact, value what have produced now in the morning, actually, you all know in the 1 rupee rate is now as on today, they're losing huge money, please, madam. Farmers are losing huge money there actually for the
2007,
development. Yes, my lord, 2007-8, and they have not paid that amount as on that day itself. Last year they have deposited, means all these years interest was also not, has to be calculated, and the plants which are left out, that has to be considered.
Plants, what do you say for that?
That is, trees.
Trees.
Yeah.
Lying on trees, my lord. Tree. My lord, the SLAO, my lord, after conducting merger, while preparing the award, my lord calculated the trees. And according to him, my lord, it is only 150. And in that award itself, it can be seen, my lord. He has given the calculation of trees available in the land. But they realize they are relying upon some other merger, my lord, which is not put in the evidence.
It is produced in the evidence, please, madam, exhibit P 23. That is not considered by the court below. That is what my.
Today, merger 23.
P 23.
There is reference of the trees in the award.
Yes, my lord.
How much SLAO is considered?
SLO is considered, my lord. Dega 150, ತೆಂಗು 15, ಹೊಂಗೆ 1, ಮಾವು 1, ಎಳ್ಳಿ 1.
Where is that? Where you are reading?
Yes, ma'am. I'm just following.
Award ಇದೆಯಲ್ಲ ಇಲ್ಲಿ. It was from the award, copy was-
Exhibit ಹೇಳಿ ಅದು.
This is 31/5/2008, no?
Yes, ma'am.
Huh?
31/5/2008.
Along with the appeal you have produced, no?
Yes, ma'am.
What is the survey number?
109.
109, part 2.
Which page of the award?
After the award, my lord, there is one page, single page like this, vertical.
In appeal?
Yes, no, not
In
in
the
a
trial
page.
court records.
Trial court.
In the
record.
trial court records.
What is it, exhibit?
Exhibit P2, my lord.
Chart exhibit P2.
ಇದರಲ್ಲಿ next page. Item number 18.
Satish,
ಸತೀಶ್.
ಹ್ಮ್.
ಅಲ್ಲಿ ತೇಗ 150 ಅಂತ ಹೇಳ್ತಾರೆ. ಇದೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ SLA ಮಾಡಿದ್ರು. ಬಟ್ ಇವರು ಹೇಳ್ತಿರೋದು ಅದು 348 ಇತ್ತು ಅಂತ. That is a discrepancy.
That is not correct, actually. That is the reason we filed an application for resurvey. They have done that, and that is the Master, please, my lord. What we are saying, the exhibit P23.
Where you filed application? Reference court also consider the same thing, no?
Yes. Same thing is considered.
Reference court has not considered that Master, what we have produced.
15 coconut trees ಅಂತ ಹೇಳ್ತಾರೆ. One each banyan tree.
They ought to have been relied upon exhibit P23. As per 23. Exhibit P23, Master, as per the.
What is the direction for preparation of merger at P23?
Mention. ಮಹಜರ್ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 48 ಪ್ರಾಧಿಕಾರ ಅಧಿಕಾರಿಗಳು ದಕ್ಷಿಣ ರೈಲ್ವೆ ಸಮಕ್ಷಮಲ್ಲಿ ನಡೆಮಾವಿನಪುರ ಸರ್ವೆ ನಂಬರ್ 109/2ರಲ್ಲಿ ಕ್ರಮವಾಗಿ 17 ಗುಂಟೆ ಮತ್ತು 30 ಗುಂಟೆ ಒಟ್ಟು 1 ಎಕರೆ 7 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಕೈಬಿಟ್ಟು ಹೋಗಿರುವ ಮರಗಳಿಗೆ ಮತ್ತು ಬೋರ್ವೆಲ್ ಒಂದು ಗುರುತಿಸುವಿಕೆ ಕಾರ್ಯದಲ್ಲಿ 9/3/9ರಂದು ನಡೆದ ಸ್ಥಳ ತನಿಖೆ ವರದಿ ವಿವರಗಳು.
There is no direction.
Yeah.
Who has done this? Why it is done?
That has not been, maybe.
At least you should show the order of the court. Pursuant to the order of the court, this is done. 2009. When award is passed?
It is passed from
2009. For award, this is done. Immediately after award, this document has come. We don't know how it has come.
Yes, we have filed an application.
Where is that application?
That is not produced in the code below, but they have also not mentioned actually why they have been, Mazar yak madidru anta alli bandilla. Mazar has been conducted.
How we have to presume the things?
This is an official document, please. Official document, why they will come and do it.
No, you would have evidence on this merger. They would have disputed. Nothing.
Evidence has been conducted. Based on that only, it has been marked as exhibit P23 in the code below.
It's not that all trees, unless it has a certain age, they will not give the compensation, consider for compensation. Nothing of that sort, just number they have mentioned. If tomorrow, after acquisition, if I go and plant one tree, can it be a fruit bearing tree or compensation granted for such tree?
They have not disputed it, please, my lord. In the trial court, respondent has not disputed.
All right, we'll consider that.
And so far as para 15 of Rao, please, my lord. Exhibit P48.
What is it, exhibit 348?
Yeah, yes, ma'am. That is orders in LAC 55 of 2017, please, my lord. Wherein for coconut trees, they have granted 17,000 rupees, please, madam, per tree. And for honge tree, 3,000 rupees were granted. Case on hand, the court below has compensated up to 5,761.
LAC of 17, acquisition of which notification, we don't know.
In the same district, whatever the notification, please, my lord, that is of 2006 and 7, 2006 and 7.
Eight.
My lord.
8 of the notification is relevant, even for considering the value of trees. If it is a notification after 10 years, value of trees will be more naturally because the
Age of the tree.
Yes, my lord.
value, and not only
Date
that,
of the
the value of money also comes down with advancing time. Therefore, what is worth 10,000 in 2000 will normally be worth much more in 2010. Therefore, is this LAC 55 of 2017 in respect of the very same notification?
That is of the notification of the year 2006 and 7. It's
Where do you say?
yeah.
Where do you say so?
Please. Yeah, prior to that only, exactly they have not mentioned 401 notification, page number 3 in the judgment. They have not mentioned that yeah, when the acquisition under section 9 and 10 of the Land Acquisition Act, so also they mentioned. But whereas in para 11 of the orders, please, my lord, that LAC dispute arose in the year 2013. Acquisition proceedings are of the year 2009 and 10, please, my lord. Para 11 only they have mentioned.
Acquisition of?
My lord.
Acquisition of?
2009 and 10.
9 and 10 is different.
Our case is 7, 8, 7 and 8, 1 year difference, please, madam. That amount can be reduced.
Tree of a 20-year and coconut tree of 6 months also, there is a difference.
Age of the tree.
Not
You would have examined the horticulture expert to say that this is a calculation, this is the age of the tree, this much of fruit bearing tree, this is the value of the tree. Nothing of that sort. You just rely on some judgment of subsequent year and say that consider 20,000, 7,000, 8,000. That may not be.
A small difference could have been, please, my lord. 17,000 will 5,000 stone difference.
No, 2,000 rupees it is considered.
No, my for coconut tree, 17,000. They have considered for compensation 5,760.
No, in our case, 2,000 rupees.
In that case, 17,000 rupees they have done. 15,000 rupees difference for 1 year difference plant. That is.
But there may be a lot of difference between the age of the tree. We don't know.
So if that is the case,
Cannot go there and measure, and we don't have expertise also.
Now we should go.
Evidence is required, sir.
Now
I understand, but evidence.
Matter has to be referred back for conducting evidence. That will be lengthy process again.
Unless evidence is there, even court, the trial court also will not be able to say what is the value of this tree. Unless horticulture experts comes, forest department expert comes and says that this is the age of the teak tree, this much of square feet of the tree in market value, after removing this much, this will be the profit and this is a value. That is
I hope evidence, I hope that they have been elicited.
Treaty 5,760.
Here in reference code, enhanced 2,000 rupees.
Yes. Yes.
Earlier, originally how much?
Total like for total of 15 coconut trees, 86,400 was fixed.
Reference code 2,000 enhanced,
Enhanced.
8,000 per tree.
5,765 calculated. 15 coconut trees.
No, reference code judgment you please see.
Yes.
For loss of 150 teak tree, 86,400 for loss of 15 coconut trees and rupees 2,000 each for the loss of banyan tree.
This is enhanced compensation.
It's enhanced compensation.
Of 3 lakh for loss of 150 trees. 86,400 for the loss of 15 coconut trees. and 2,000 each for loss of one each by banyan, ellie and jackfruit trees. Enhanced compensation of 13,500 for the loss of Hercules tree. 20,000 for loss of 10 silver trees, 56,000 for loss of mango tree.
That's how can we sit here now?
Yeah, just only my lord on the market value. If you are just challenging the market value. There.
So far as the teakwood's tree are concerned, please, my lord. In fact, in other judgment, they have relied before the court below, that is 34,842 rupees has been granted for teakwood trees. So that can be considered and calculated for the trees, what they have saying that. There is a difference of 150 trees. For that amount has to be calculated. And for coconut tree and other trees, difference amount has to be.
We'll consider.
That.
Great level.
Much.
Two 30 matters, the number 50, A.V. Narsin.
Place the authorities, my lord, on record. Like
Yes.
that. I just passed. Briefly, my lord, I have stated my contention. Two citations, my lord, is what I'm referring to. First, my lord, is in the case of 3 H.M. Mahadevappa versus 2 location in RSA number 139 of 2008. Third, the relevant page, my lord, is page number 46 of the said compilation. It is regarding, my lord, an identical matter where, my lord, a contention was taken likely that it was a loan agreement and not a sale agreement. And it was dealt in this fashion, my lord. Page number 46, internal page number 40 of the file.
40.
My lord, internal page number 40, running page number 46 of my compilation. So the 3 lines from the bottom. The consideration shown in Exhibit P1 is not just on the lower side, but shockingly inadequate. Instances of advancing loan and insisting for a registered agreement of sale as security for the same is not uncommon in our country. Having considered the principles laid down in judgment and also considering the circumstances under which the document came into existence in the case on hand. Also, and the plaintiff is government employee working as a teacher and admitting the defendant is a farmer and not having any worldly knowledge, and also taking into consideration of mentioned in Exhibit B2 in respect of the property, which is located in the very same property as well as the nature of the property and so on. The sale consideration in respect of 5 acres of land is an amount of 45,76,000. But in the case on hand, in respect of the extent of 4 acres as 3 guntas, only sale consideration is 2,89,000. And it is nothing but shockingly inadequate, not on just lower side. These are the aspects ought to have been considered by both the courts. Both the trial court as well as the first appellate court even not discussed anything except discussing section 20 of this specific fact. The evidence available on record has not been discussed in detail with regard to exercising the power under section 20 of the specific fact. While exercising the discretion, court has to take note of the facts as well as the question of law, and the same has not been done by both the courts. The answer elicited from the mouth of the witness of the plaintiff regarding the availment of loan by the farmers under difficult circumstances, also not discussed while exercising discretion. Mere execution of registered sale agreement of sale itself cannot be a ground to grant the relief of specific performance, and the court must be cognizant of the conduct of the parties. Hence, I answer the substantial question of law, and this honorable court, my lord, set aside the concurrent judgment granting specific performance and modified the order. The second judgment, my lord, is Rajesh Kumar versus Anand Kumar. That is on latches. My lord, relying on the three judgments, my lord, in Shardamani Kandappan, Atma Ram, my lord, page number 59. The compilation. The latches, my lord, was taken note of the Honorable Apex Court, and the observation, my lord, is telling note, my lord, what has been stated in the Shardamani Kandappan in paragraph number 16. This court held that every suit for specific performance need not be decreed merely because it is filed within the period of limitation by ignoring time limits stipulated in the agreement. The courts will also frown upon suits which are not filed immediately after the breach or refusal. The fact that the limitation is 3 years does not mean that the purchaser can wait for 1 or 2 years to file a suit and obtain settlement. Then Atmaram, my lord, is recorded, and then eventually the Supreme Court, my Honorable Apex Court, my lord, says that latches also is a serious thing that will have to be considered. The holistic view, my lord, of the
Yes.
my lord, the circumstances, my lord, which I made a submission on. Very briefly, my lord, I have narrated. Made in point wise, my lord, and for my lord's consent. So overall, my lord, as this honorable court, my lord, observes in the first of the cited judgment, the overall conduct of the parties is something that will have to be required to see whether a particular transaction is an agreement to sell or a loan transaction. 2007, an agreement is entered into, no title deeds whatsoever been examined. Simply, my lord, 2 documents being named, 14 months given. And then, my lord, to improvise the case that after 1 year I came and I wanted to take the sale deed, but she insisted that she wants some more money and hence a supplementary agreement was entered into. And then, my lord, not taking any steps. And notice being served, and that is not served upon me. And then thereafter, my lord, to file a suit after 1 year. So eventually, my lord, 2007 would be the alleged agreement and suit comes to be filed on 6/4/2010. The way in which, my lord, PW1 has answered the questions, being an incompetent witness, as I must respectfully made a submission. My lord, the agreement, my lord, would not be proved, is my respectful submission. Yes, I pray, my lord, my plea.
Yes. Yes. Yes.
balance of 6,22,000 prepaid. Now they give it paid. Now prior to paid this. On this, on that paid the price. These that have been landmark before one of that in a nutshell, the arguments are not paid. Consideration is not paid. There is no consensus side item. Witnesses are not being examined. And it will actually really do particular. Secondly, madam, make it so convenient for us. Second convention is document in the nature of loan agreement, but not permitted to be marked with a trial test. So that is the crucial document on which that is like therefore that then third condition of the opportunity of to read this was not given. That is also added on. After the DPA was the plaintiff himself was not coming to the DPA when it was done. Then the first time, the agreement was not moved at the trial. Now, number three, also third one is wrong. The first time it was done and has not brought to the notice of the court, the government's name of the country made of the defendant in the written statement. And they about it in the written statement. Page 25 of the paper.
Page 20?
Page 25.
Yes.
Defendant states that during the 3rd week of April 2007, he had approached the plaintiff and appraised her about the economic crisis faced by her family and requested me to help her economically. Defendant has also requested plaintiff for a hand. Defendant states that plaintiff has to send the money in the form of hand loan. Defendant states that later, when giving the cash amount and state has insisted mandate defendant to execute the document into the police for office. Defendant states that on 17/4/2007, he had approached me for the police for office and asked me to document to move the police to the act of taking the role of the police officer. And come to the lower aspect of cases have executed an agreement on one basis only, and in the transaction of the mortgage and the cancel agreement, collecting cash amount of 41,89,000. Therefore, this is the consideration, 41 lakhs is admitted. But what they are saying is that it is in loan transfer. And the amount was repaid to the claim.
Yes.
Two things are admitted. One, the exclusion of the two of them, and also the receipt of the transaction. These are two admitted facts, clear according to the legal statement. Now, what is the and there are also in that same consideration is admitted. In the year 2007, I was prepared to buy approximately 2 acres of land and paid almost half of the fee at that point of time in the year 2007. Now, after admitting the land, 6 of the same country, and also the discount of that, they do not come before the they is a loan transaction. And even after the lease is a loan. Now, kindly consider whether they have made any effort to return the money at all. From 2007, was any notice issued? 2008, supplementary estimate, further advance they have taken. Has any further notice been issued by the, was a contention taken in the written
In the written statement, there is no such contention, that there is an attempt to return the money and take.
No attempt made at all. No notice, nothing, not even a submission made in the written statement saying that, look here, we are depositing, we have taken this as a loan amount, we are depositing in the court. No such attempt has now never been made by the defendant whatsoever throughout the proceedings. And it has become impossible for me at this point of time, if some of these offer to purchase 2 acres of land, anywhere close to Bangalore. In fact, this particular piece of land was at Cooperative. So, you know, today, it is not less than 4 an acre. The value of the money, 2007, cannot be compared to the value of money today. And if you say here is a loan transaction, ready to repay it along with interest, could be unjustified. Second, we have paid document in the nature of a loan agreement. According to them, they have filed a loan document, which was an unregistered document, perpetually a loan agreement, and it was confronted to the plaintiff, the witness. It was not even a document which was registered. Unregistered document. We don't even know whether it was a Xerox document. That application along with the document, apparently, I don't know if the document was produced, but what has happened is, Time Court has rejected that document, saying that here, probably you can produce it at the time of dependence evidence. There is nothing prevented them from filing it at the time of dependence, so that marking it to a dependent. They could have very well marked the document by producing the document and to the dependent. Each they should have produced the copy to the court. Before the evidence, commencement of the evidence, they have not done so. And for a minute, even a feeling of that if the court had marked the document as their own, Even then, are they in a position to enforce that agreement? It is way beyond limitation. Therefore, I understand. Even if it is admitted, I humble request, that cannot be reminded back for interest into the question whether the loan document that was talking about, saying that the loan document is going to market, and therefore, this should be to mark the document, even if it is marked, even admitted, even some, it cannot be. Therefore, we have found that opportunity was not given to them by the trial court to mark the document only untenable. The fourth contention is they were not given an opportunity to lead the defendant's evidence. In my humble opinion, the Lordship may kindly take the order sheet of the trial court for a minute.
Six, 13.
Take 13.
Yes. Defendant followed absent. On 3/10/2013. 3/10/2013, defendant followed absent. 9/10/2013, defendant followed absent. 5/11/2013, defendant followed absent. And all the cases were claimed. 18/11/2013, defendant absent. It was the defendant suffering from violence. It was not the case of the defendant. Apart from that, there are from 13/1/2014 on no excuse is made on that day. He had to be present. If he was not able to present, a commission should have been appointed. Commissioner should have been appointed. Application could have been filed. No application for commissioner has been. Examine the witness. Thereafter, on 31/2014, all out. Then 31/2014, defendant followed once again absent. Here, once again, there is no application made or memo filed to say that yes, she has continued in the hospital. We cannot bring her to the court. Nothing more such thing. Thereafter, what is beyond the case of harm? Thereafter, on once again,
7/3/2015. No more place for that. So, please ask me to give us. We can use for argument. And, follow. 20/6/2014. Next week is the argument. Thereafter, finally, judgment was announced. All through this time.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
File an application to recall the witness. If they have filed an application, recall the witness. Then they are supposed to consider and on the merits. That is not the fact. Right for the fact that you have seen that what dependence is. And sufficient opportunity. It is not as much as there are. An opportunity. I am on the people that I am the father. Actually, Defendants are not made there. Then you know they want to make it accept law adverse interest. Not the order. That is what is practice not very possible. The most important thing according to me that and therefore all these transactions happen. And the plaintiff has suppressed so many things and got the signatures because she was ignorant and all. And all that is false for the reason that suggestions made by the defendant's counsel to the witness very clearly says, page 50. And the welcome for the reading. But then, defendant is the housewife. Defendant is think of the defendant. Is working in the local defendant, possibly local department. It is not it is not as if it is not where leaders of the government, leaders from documents, and details in the agreement for say, etc. It's not as if it is not awareness. They are very well aware. Defendant itself is not able to be constantly people into the agreement, but the defendant and because it was contract and the people of the agreement, the of our man. Also admitted, have signed here or signed the document. Not as if the plaintiff has somehow suppressed and taken advantage of the fact that they wanted a loan and advance money and you did agreements, you kind of cheated them profit. That is not so. Fact is, defendant was a government. He was very well aware of all the nature of the transaction, of the sale of the etc., contract, and all its permutations in common. He was very well aware of it. But in spite of it, he has taken up a contention in the written statement, admitted the agreements, taken up a contention, it was no transaction, and later on they have failed to enter into the witness law deliberately after giving, in spite of giving the data, several opportunities. And failing to produce the document on which they have relied upon to say it's a non transaction. Therefore, 2007, I paid them most half of them. And substantial sum of money. And this point of time, the value of the money is completely eroded. And it's impossible to do the same. If it was a loan transaction, and if they return the money within a period of 1 year, 2 years, or 2 years, then
On the 13th of the time I filed this case, even then, there was ample opportunity for me to buy some other property. But unfortunately, today, I cannot. Therefore, in my mother, I was right in between this. Because he has proceeded on the basis of the material available to the court at that point of time. After the appeal stage, it is easy to gain the trial court level for paying the material, every third out. But that was all the material available. There was no defendant's evidence. The Supreme Court has said, these are approach intention of defendant's evidence. Therefore, the numbers of this are not thankful.
Briefly, my lord. But now, a suit for specific performance is an extremely equitable. Now, the conduct, my lord, that will have to be proved to be, my lord, beyond any blame is of the plaintiff. Now, plaintiff must specifically take a stand as to the nature of the transaction. A casual approach by examining a person in form of a GPA who doesn't know anything, and then, my lord, to say that let there not be any adverse inference drawn against me, and let everything be against the defendant. It is totally against the way, my lord, in which the burdens of proof operate in a civil litigation. Now, it is ultimately the plaintiff's burden at the outset to prove that there is a valid execution of the agreement to sell. That is where, my lord, I relied upon the citation also. Mere registration of any agreement will not conclusively prove the nature of an agreement. Now, what is the specific case? Now, it is not, my lord, regarding the fact as to whether 41,29,000 have been paid or not. In what capacity it has been paid is specific case that has been made out is on that day I have paid you 32 lakhs is the specific case that has been. Now, no proof, no evidence, no pleading, contrary, something else emerges and to say, second month of 2007, something else had been paid and now you need to adjust it, etc. There cannot be, if at all a particular agreement is set up and passing of the consideration is propounded, my lord, under that agreement, it has passed this specific case that will have to be. Now, I stated that I have an agreement in which the nature of this transaction has been spelled out, and that is what has been confirmed. Now, I do not understand where the law of limitation will ever come as far as that agreement is concerned. If it's an acknowledgement about the nature of a particular transaction, it's stated to be a loan transaction. There is absolutely no law of limitation that will come. Now, I had put it as a defense. It is not a case, my lord, that I have taken by surprise. Now, it was also, my lord, as I mentioned, my lord, confrontation is one of the recognized method under which a document can be introduced in an evidence. There is no barring of the defendant from entering the witness and introducing a document, my lord, by way of confrontation. Now, when it is being confronted, plaintiff doesn't want to come. It's for him. He runs the risk. Now, that is where, my lord, I pointed out how PW1 selectively, my lord, admits the signatures that is forthcoming on the said agreement. So, what is important here is, my lord, what is the nature of the document? And hence, what has been relied upon by the learned senior counsel, my lord, regarding the judgment rendered by the Honorable Apex Court in Ramasubramanian's case. It was a case of open and shut case where, my lord, the agreement had been specifically admitted. The defendant admitted the agreement, and also that under the agreement, the substantial sale consideration has passed to me. And then that is where, my lord, the Honorable Apex Court said, under the provisions of the specific relief act, if at all there is a proof of the agreement and the amount has also been paid, nothing else is required to be done. Because readiness and willingness is also a part of it, it can be inferred immediately. But here is a case, my lord, where there is a transaction, my lord, is specifically being disputed. Now, what prevents the plaintiff from examining the plaintiff himself or any of the witness? He doesn't want to do that. And hence, the very purpose of which, my lord, the witnesses are brought in and the signatures are taken is to see to it that the transaction ultimately, if at all is in dispute, could be proved in a manner known to him. He doesn't want to do that. And on his specific, my lord, submission before the court, saying that I do not have any other evidence to lead. My lord, the evidence of PW1 was good and my evidence was good. My lord, I also showed, my lord, that with a memo I have produced the medical records. Of course, 10 dates, I do admit, but the span of time is 6 months. So there was a predicament is what I have been able to show. Now here is a case of a head injury versus a person who alleges that he had a diabetes and hence he cannot come to the court. Hence my respectful submission is where the adverse inference will have to be drawn is something that the court will have to necessarily see. Now 10A to 10J reciting the entire deposition is not the quality of appreciation of evidence that can be expected from the trial. Now, having narrated the entire evidence, now the court will have to come to see whether these circumstances, having regard to the conduct of the parties and the circumstances in which the alleged agreement has come in, whether this could be called as an agreement to sell or a loan transfer. This discussion, at least, my lord, is something that should be. So, though cryptic, the trial court could not have done much more than this is not the answer. Trial court will necessarily have to appreciate the evidence and then say, notwithstanding all these facts, I come to the conclusion that the agreement is there. Ends the matter. But the trial court, my lord, would never do that. Para 11 is dedicated for adverse inference. Para 12, my lord, one paragraph is written and then it's suit. That is not, my lord, the standards that is expected when a suit for specific performance when disputed facts regarding the nature of the transaction. Hence, my respectful prayer. The appeal.
Number 38.
May it please. My lord, I was taking the Honorable Court through some of the documentation, my lord. I'll quickly, my lord, finish the rest of it and then go to the oral evidence. Honorable Court may please see, my lord, now the draft sale deed, your lordships just saw, at page number 87, we also purchased the stamp paper. In those days, my lord, there was no direct online payment as we have now. We had to purchase non-judicial stamp paper, get it engrossed, and then present it to the court at the sub-registrar. So that stamp paper was also purchased. That's at page number 87 to 89. Now, there are few letters at that time, Lord. I'll quickly take a lordship through that. Page 91.
Yes.
This is from us, the plaintiff to Mr. Kumar. It's letter dated 11/11/95. We are expecting you to come on 9th as promised by you for execution registration of the sale deed in favor of Arvind and myself in respect of property number so and so. Meanwhile, on 31st October, I already taken challan from Deputy Director, Government Karnataka Treasury, remitted the amount to Reserve Bank for getting sale deed, which was approved by you, duly embossed. Since you did not come on 9th, I have not remitted the amount to Reserve Bank, though sale deed is ready. Kindly advise me date and you propose to come for execution of the registration of the sale deed because I'm holding the cash. I had drawn for remittance towards stamp duty. I trust this finds you and family in good health. Now, this in November, a month later, one more letter, not at 93. in which, my lord, he is recalling the payments made. Dear Kumar, in fulfillment of para 5 of the lease agreement, I have paid you 50,000 over and above another 50,000 already paid in pursuant to lease agreement. Total amount of 1 lakh already issued me a receipt. We have exercised our option to purchase the property and fulfill our part. Then we request you. Then, my lord, next para we say you are to come on 4/11. You did not come. Then again he refers, my lord, that I paid everything and I'm waiting. And after this, my lord, there seems to be a decision that they will not proceed further. So, my lord, matter moves to legal notice stage at 96. Where at 99, my lord, we give all the details and say we call upon you to execute the deed. And there's a reply at 101. Lord, in the reply at page 102, third line, our client states that it is true that a registered lease agreement was entered into between the power of attorney holder of our client and your clients. And according to the said agreement, your clients have to pay a monthly rent of 100 to our client. Our client states that your clients have not paid any amount by way of rent from the date of the said lease agreement. Same was demanded for by our client orally on a number of occasions. Since there's good relationship between our clients and your client, our client made oral request for this sum. Rent has never been paid. So you have to vacate. So there is an admission of the power of attorney. There's an admission of the document. The only reason they give is this non-payment of rent. Next paragraph, they talk about the balance. Further, our clients state that as per agreement, your clients have to pay 1 lakh to invoke clause relating to sale. According to the said agreement, your clients have paid 50,000. Balance 50,000 is not paid till date. Our client denies receipt of any other payment from your client towards the account. Then they deny that sale deed date was fixed and all that. And finally, they say at page 103, our clients further state, second paragraph, that the above lease agreement was entered into on 6/2/75 between your clients and the power attorney holder. But your clients have approached you only in 1996 after a long lapse of 21 years for issue of legal notice and a reply. That itself shows that your clients have no right whatsoever over the property in question. Further, your client's contention that your clients will go for specific performance is also barred by time. Then, my lord, another reply is sent. And thereafter, my lord, your lordships have seen that draft of the indenture of lease, etc. Not one more document which will show, my lord, that there was no dispute about the documentation that has been entered into is, my lord, a memorandum of family partition between the defendant and his wife. It's at page 139, para exhibit number P35, page 139. This is in the year 1981. Not he gets married in 81 only. And immediately thereafter, they enter into this family partition. In this, they clearly admit, my lord, about the sale of the property and other things. Whereas the family of K.D. Seshadri, son of D.K. Seshadri, hereinafter called HUF, consists of the following: K.D. Seshadri and Srimati K. Rajeshwari. At this point of time, my lord, they still did not have any children. They were only husband and wife. Whereas the HUF owns, in addition to scheduled property, various properties, and parties to this partition are dividing scheduled property among themselves. Whereas scheduled property is in the occupation of J.R. Seshadri, son of T.K. Rajan, K.T. Rajan, the cousin of K. Seshadri for 10 years, who is also made a party to this partition, hereinafter called as third party. This is, my lord, another portion of the property, not this subject matter, the suit property. Whereas K.D. Seshadri Karta, under the right he enjoys as Karta, has directed that above property be divided as under. Mr. J.R. Seshadri, by virtue of being a tenant in the scheduled property, is being given a share so that the scheduled property can be divided among the other parties to this deed. Now, this memorandum related to oral partition, as described above, to be detailed here and there, that K.D. Seshadri has kept property described in Schedule 2 and marked green and brown in the map enclosed. That Srimati K. Rajeshwari, second party, has agreed to take the portion described in Schedule 3 and marked red in the map. J.R. Seshadri, third party, has agreed and taken portion described in Schedule 4, blue. It's agreed between parties to this deed. The second party shall have right of way to reschedule property through the property described in Schedule 2 and marked in yellow in the map enclosed, fallen to the share of the first party. A true copy of this document is given to second and third parties. They have agreed not to resile from this agreement, not to dispute each other's share. Also, each is free to deal with his share as he desires without reference to the other. Market value may be. In addition, agreed to and assumed other, he will attest to other document. Last sentence. They have also agreed that plot number 7/1, having dimension number 82 by 104, leased to Dr. Ashok, will be conveyed to Dr. Ashok. So, the effect of this document is that the so-called claim of a HUF will not arise because before the children were born in 82 and 83, the family had been dissolved. And between husband and wife, who are the only two persons who could possibly have a claim, the wife got whatever was allotted to her, the husband retained the rest of it. So this entire argument based on partition of a joint family property, my lord, would have no legs to stand. And this document can be, my lord, noticed for two reasons. One is that aspect. Second is that they are reiterating that they are going to sell this property. The stand which they now take is completely contrary to that this document. Then, my lord, there are 2 or 3 more special notices issued by the corporation, which do not assume too much importance, but just for completeness of record, to show that I have always been recognized as a person being in possession, in occupation, and who has been paying the taxes. Then, my lord, P33 is one document which shows the rent receipts at page 121. Stamped and signed in 81. But the stand they take, my lord, in the proceeding is I have not received any rent at all.
Yes.
Then, my lord, I've already taken your lordship, my lord, to the evidence in the other companion, in the earlier case. This brings me, my lord, to the end of the documentation in this case. Would your lordship, my lord, now permit me to show a few sentences, my lord, in the evidence? For that, kindly take the other volume, my lord. That is the first appeal memo itself. I think all the papers are filed along with it.
Yes.
The plaint, my lord, is page 1. The 4 witnesses have been examined. PW1 is the plaintiff. His evidence begins at page 37. But I'll not bother reading the the main affidavit evidence, my lord, because more or less the same as the plaint. He refers to all the documents. And the explanation, my lord, for not completing it in time, the lordships will get at page number 42, para 10.
Yes.
In the first week of February 96, I told the defendant that I am exercising my option to purchase lease scheduled premises and the balance sale price will be paid on the date of registration. Requested defendant to fix the date for registration. Defendant told me as in his building construction work he has entangled in tax problems, it is not possible for him to obtain income tax clearance certificate in the near future. Therefore, execution of sale deed is to be delayed. Defendant told me that as he will be in need of income, I must oblige him by paying whatever the amount he needs, and the same shall be adjusted towards the balance of the sale consideration. As desired by defendant, I paid to defendant on various dates by checks and cash along with monthly rental of 100 rupees. Checks issued by me have been encashed by defendant. There are entries to that effect in my bank passbooks. Certified copy of the bank passbooks are here produced and marked as so-and-so. The relevant entries are also marked. Defendant has also issued stamped receipts duly signed for having received the rents from 77 to 81. Said receipts are produced as so-and-so. The signatures of the defendant in 4 places are marked. J.R. Sheshadri, the GPA holder defendant, has also issued duly signed stamped receipts for having received rents from 73 to 81. Same are produced as P12. Signatures on the receipt is marked. He has also issued statement of rents. Then they refer to consolidated statement, etc. At page 48, I refer, my lord, to the draft sale deed, which your ladyship has already seen. Para 15, third line. I got prepared a draft. Draft with corrections made by defendant, okay, and initial by defendant on file 11 is produced. His examination in chief continues, my lord, with marking of all the documents. In the cross-examination, will commence, my lord, at page 60. Initially, my lord, there is some facts elicited about the antecedent, the title, the relationships, etc. At the bottom, my lord, of page 61, there's some question about family properties after Diwan Sheshadri Iyer, and he says there was a partition at that stage. That 62 bottom, he says in the partition with his grandfather, his father got a house by name Kumarakot in High Grounds. Then, my lord, at page 64, there's a death of Mr. D.K. Sheshadri, father, and the fact that there was no partition. At page 65, he refers to the intestate death of his father. Last para in that page, it is true to suggest the defendant married K. Rajeshwari in the year 1981. It is true to suggest that Vinod Kumar was born on 24/5/82. It is true to suggest that the younger son of defendant was born on 22/5/83. Myself and defendant are on good terms. If it is suggested to me that there is no partition between defendant and his sons, I state that to my knowledge, there is no partition between them. It is suggested to me that defendant and his sons constitute joint family. That may be true. It is not true to suggest that the said suit property was not the absolute property of the defendant. It is not true to suggest that the suit property belongs to sons of defendant. Witness volunteers that when the lease deed was executed, sons of the defendants were not even born. Then, my lord, at bottom of page 67, there is little bit about why this document was styled in this manner. 3 lines from the bottom. It is not true to suggest that during 72-73, I did not ask the defendant to sell the suit property to me, and I negotiated only for lease of the property. It is not true to suggest the defendant never told me that he had income tax problem, therefore he cannot sell the property. It is not true to suggest the defendant did not suggest for lease of the suit property for 98 years. Not true to suggest defendant did not give any option to me for purchasing suit property under the lease deed. I have read the plaint. Not all these averments are not admissible in evidence at all, my lord, under the Evidence Act, section 92, contents of a document which is signed by the parties. To that extent, they will have to stand by the document itself. Then, my lord, power of attorney, there is a lot of cross-examination of where the original is, etc. At page 70, last para, in the year 76, the market value of the suit land was 1 lakh. In 1995, when I wrote letter to defendant and got issued notice through advocate, I exercised my option to purchase suit property of 1 lakh. Market value in Malaysiarum in 95 was 1,000 to 1,500 per square feet. It's true to suggest that area of the suit land is 8,528 square feet. Why did you not take legal action against defendant for enforcement of agreement if you are ready in the year 1976? Since defendant was my cousin, I was not willing to take legal action against him immediately as he was postponing the pleading his income tax problems. Then, my lord, there are a number of questions that relates to power of attorney, etc. I'm not going to trouble the honorable court with that. But please go to several pages, my lord, about execution of the document, about initials, etc. Then, my lord, this is even a suggestion that P17, which is the confirmation letter, my lord, about the rents at page 117. Question, last question, penultimate question. I put it to you that exhibit P17 is created by you for the purpose of this case. Answer is no. Of course, the document is signed. Now, my lord, the next witness is at page 118. He is one Devi Prasad Chaudhary. My lord, he is one who purchased a portion of the property, of the adjoining property, from the same family for the purpose of development. My lord, there's a sale deed P34 executed by the wife of defendant, that is Srimati Rajeshwari, in favor of the wife of this witness. Now, how the transaction took place, my lord, he narrates at the bottom of page 118, para 3. I was previously residing in a rented house in Rajajinagar, looking for a site to purchase. One Nanjappa, a broker, came and told me there is a vacant site at Malleshwaram. He took me to meet J.R. Sheshadri, who was living in Jaimal area. He told me that the site in Malleshwaram belongs to his cousin K.D. Sheshadri, and if I am interested, he will take me to Chennai. J.R. Sheshadri is handling all the matters pertaining to properties belonging to K.D. Sheshadri. We went to Chennai and met K.D. Sheshadri. K.D. Sheshadri told me that the site belongs to his wife, Srimati Rajeshwari. Then Rajeshwari and K. Sheshadri and his wife agreed to sell undivided title interest in land bearing survey number 7/6, measuring 66 by 82 feet on 12th May, so and so. They also sold to 10 other persons undivided share right title interest in the land. Rajeshwari retained one share. Then not what he was supposed to do, he constructed, etc., etc. Then not page 120, para 5, is referring to the partition deed. At the time of purchase, K.D. Sheshadri gave me copies of the documents relating to the said site, which included copy of memorandum partition deed entered into between Sheshadri, Rajeshwari and J.R. Sheshadri, cousin of K.D. Sheshadri, also GPA holder of the properties belonging to Sheshadri. This partition deed was dated 3rd June 81, which I am herewith producing the same. I am also given a copy of the special notice, etc. Then he starts the work, etc. These people have cooperated with that work going on. And then he completes the work. So the reason, Lord, this witness's statement is for two factors. One is to show that the partition between husband-wife, joint family, and that some portion was sold. In the partition the wife got, that she sold.
Yes.
My lord, then in cross-examination only, just 1 or 2 lines at page 126, my lord, he is explaining the relationships in the cross-examination. Now I see page P34. It is true that it's a sale deed executed by the wife of defendant in favor of my wife pertaining to property abutting to the suit property. It is true that I am one of the attesting witnesses to P34. It is true that contents of P34 are correct. And they refer to antecedent documents, etc. and other things, which are not relevant. He is also a contractor, he says. The next person, my lord, is a chartered accountant. He should not detain us much, my lord. He had given that certificate only for that purpose, my lord. He was examined. There's nothing, my lord, much to be seen in it, except that they try to say that he didn't advise at all. And his advice is there in writing. And he refers to the meeting and gave that advice. And he stood by it in his chief examination also. Then, my lord, the defendant's evidence is at page 140. Not some very startling statements are made in this. Having seen the documentation till now, my lord, page 144.
Yes.
He is referring to the power of attorney. What he says is, in any event, admittedly, the said, I'm reading at the top, the said power of attorney, exhibit P29, does not contain my signature at pages 1 and 2. The initials at pages 1 and 2 in P29 are not mine, but they were forged by the first plaintiff. The first plaintiff replaced pages 1 and 2 of P29 and thereby introduced the clauses fraudulently and without authority detrimental to my interest. This is a power of attorney he is referring to. I never gave consent of authority for the aforesaid clauses or options to purchase sum rupees 1 lakh as claimed by plaintiff. I gave consent for the lease only for a period of 2 years in favor of plaintiff. P29 is a manipulation by the plaintiffs. P29 is not registered document. It only attested by the sub-registrar. That is true. He appears before the sub-registrar. Sub-registrar attests the document because your lordships will get that attestations in the original Milord document in the trial court record. There's no doubt about that. And the fact that he executed this document is admitted by him in judicial proceedings and other proceedings. Then Milord, at page 148, apart from saying that they have no right, I have not entered into this agreement, this is again another very startling submission he makes. The last para at page 148, I am not liable to execute sale deed as demanded by plaintiff, as I have not received any consideration from plaintiff as alleged. I submit that I have not issued any stamped receipt for 1 lakh to plaintiffs. The said receipt is a forged document. I submit that I have not issued any stamped receipts for any rentals for the period November 73 to December 91 as alleged in the plaint. Receipts are forged. Now this is contrary to Abatement in the legal notice reply, where they only say I didn't receive rent, that's all. Then, my lord, there is a lot of cross-examination relating to their family and other things, which is really not of very great importance in his chief examination. At page 160, Lord, your lordships may take notice of the fact that at that point of time, section 230 capital A of the Income Tax Act, my lord, provided that any property more than, initially it was 50,000, then raised to 2 lakhs. If that document has been registered by the sub-registrar, then the vendor had to go to his income tax officer and get a copy of the document attested and permission had to be obtained. So the explanation he has given is, I can't get you that because my tax affairs are in a state of mess. And at page 160, my lord, we get that. The first plaintiff's auditor, T.V. Narayan, has admitted that according to provisions of section 50C of the Income Tax Act, the property value fixed by the sub-registrar today is to be taken into consideration for calculation of capital gains tax if the sale takes place today. The said witness has further admitted that liability to pay capital gains tax is on the vendor, not on the purchaser. On the plaintiff's aforesaid admission, though their witness PW3, if the land is sold for 1 lakh today as per plaintiff's claim, I have to pay capital gains tax at the present rate on the value of the suit property fixed by the sub-registrar, which would be nearly 6 crores 82 lakhs. Hence, I submit the claim of the plaintiff for specific performance is unconscionable, unenforceable, illegal, and frustrated. On the short ground, suit claim is rejected. So this problem was also resolved by our offering to make sure that we pay that money. Then, my lord, his cross-examination begins at page number 164. His relationship with J.R. Seshadri, my lord, is elicited in cross-examination about the lower half of that page. Before shifting to Madras, practically I wound up all my business at Mumbai. I studied in Bombay. When J.R. Seshadri did his school in Bombay, he did his engineering in Bangalore in Government Engineering College in the year 50s. J.R. has shifted to Bangalore for study purpose. When he was in Bombay, he was staying with me. When I was a minor, his father was my guardian, his uncle only. During studies, JRS resided with Ashok, and after he went out for employment, when he came back to Bangalore, he stayed in my house at Bangalore. My house number 7, 12th cross, so and so. He came back to Bangalore after employment outside in the year 68, 69 till demolition of the building in 83, 84. So at the relevant time, that is in 75, JRS was living with him in his own house. After that house was at Malleshwaram was demolished, Nothing was constructed. Sites were laid out and given to various parties. I myself formed sites with the help of JRS since he was residing in the said property. I gave the sites. It was given to three parties. One was Ganesh Raju, another was KB Jairam, third was Bandappa Reddy. I gave all the three sites during the year 83-84. One site was retained by my wife, another was sold by me. One site is a suit premises. I sold the third C sites to aforesaid persons. Site remained retained by GRS that had my house. He did not construct any constructions. He sold the site in 94-95. I do not know whom it was sold to. Then, where they were living and all details are there. I'll skip those portions. Middle of page 166. Daughter is married and she is staying with her husband at USA. The daughter of GRS married in the year 2000. She got married in Chennai. I attended her marriage. Son also got married 2 or 3 years back. Function of marriage took place both in Delhi and Bangalore. I did not go to either functions because of my health and is too far away. JRS has invited me to the state function formally. JRS was residing in a rented place in Jaimala Extension, other places. So, my lord, 75 agreement, up to 2000, up to 90, he stayed there. After that, building went, that cordiality, and he attends all family functions. If we view, my lord, this in the background of his stand, that this is a forged document, I never signed pages, I never gave power of attorney, and in the face of what is contained in the document, my lord, this is obviously a stand, which is a futile stand that they take. And next page, my lord, second line, first line, he says, there is no enmity with GRS. I have normal relationship except the matter of litigation of this side and his litigation. Now, my lord, this deposition is being given in 2008. So that means up to 2008, on the date he is giving evidence also, he says the relationship is very cordial. Then, my lord, page 168. Again, that same vein it continues, about the 8 or 9 lines from the top. After JRS was staying in Bangalore, I used to come to Bangalore generally 2 to 3 years once to Bangalore. When I used to come to Bangalore, I used to attend my sisters and relatives. After I shifted to Madras, I used to come once a year to Bangalore, sometimes once in 2 years. I brought my wife also to Ashok's house where he stayed, and the said house property is the subject matter of this suit. I had stayed in the said house with my wife once or twice. When my wife was not coming to Bangalore, and when I used to come sometimes, I would stay with GRS and sometimes with the lodge. Last time I stayed with Ashok in his house was sometime in the year 1991. Thereafter, whenever I visited Bangalore, I used to stay in the lodge. So, my lord, we now come to the year 1991. Till that time, there was cordiality among everybody, including GRS and the plaintiff and the defendant also. Then, para 24 in the next page. Retention of house by JRS or retention of a portion of the house by JRS was only oral, except the partition document at the time of forming layout. 3 persons have signed the document, myself, my wife, and JRS. Said document was made in the year 81-83. It was not a family partition. It was for purpose of making layout. I do not have the said document or photocopy, etc. It's now trying to say it's not a family partition, but the document speaks for itself. Then, my lord, next few pages also the same thing continues. I'll not trouble your lordship. There is enough and more to show that there was all cordiality. Then we come to the execution of power of attorney, page 171. Para 25. I do not have a copy of the power of attorney given by me to GRS. I never had a copy of the power of attorney, witness volunteers. I had a copy of it, not there with me now. I executed power of attorney at Mumbai. He further says he signed all the pages of the power of attorney. The stamp paper used for the said power of attorney is on the state of Maharashtra. I myself purchased stamp paper. I got it drafted by the bond writer. I signed the said document before sub-registrar, put his seal on every page. I handed over original to GRS custody, forwarded to Ashok to the best of my knowledge, maybe in the year 74 or maybe given in February 75. Perhaps he's given it after registration of the lease deed. Then, my lord, next paragraph, he refers to that other suit. I will not trouble you lots with reading again, my lord. He refers to that suit 3730, where he has admitted his signature. And there, my lord, interestingly, he even denies the certified copy of the deposition before the court. Middle of para 26. Yes, I was called to give evidence in that case. At that point of time, advocate for plaintiff has confronted deposition recorded in OS so-and-so, wherein witnesses admitted the signature found up to pages 7. After that, the witness denied to admit on the ground that other pages of deposition, except at page 26 to 30, which are typed in Kannada, has not carried a signature. At this point of time, advocate for defendant has raised objection that the paper at pages 8 to 25 does not contain signature. At this juncture, same is marked as P39, same is subject to court decision. I have gone through the depositions at page 8 to 25, exhibit P39. I can say I can neither confirm nor deny in further. He said it may be his evidence generally. So, my lord, the practice, I don't know what it is in other places, but at least in Karnataka, my lord, the presiding officer will direct the witness to sign the last page of the deposition. He is not expected to sign every page, only the last page, or in some cases, they also ask them to sign in the order sheet. Otherwise, general practice, my lord, is to sign the last page. So, he is now trying to wriggle out those very damaging things that you have stated in that case. Then, my lord, page 174, he asked about where they got the stamp paper for the power of attorney. About 4th or 5th line in page 28. I verified exhibit P29. The document at P29 is prepared on stamp paper purchased by me. Later on, witness says the stamp papers were purchased in his name. Apart from myself and Ashok, nobody was there at the time of negotiations respect to lease deed. Subsequent to negotiations in between myself and Dr. Ashok informed the GRS about negotiations because GRS was in Bangalore and I was at Bombay and some of the terms are confidential. I gave the power attorney to GRS. Apart from power attorney, I did not give any other written instructions to GRS, but I really gave instructions to GRS. I can't say exactly when Dr. Ashok started construction. It may be in the year 74, 75. Most probably Ashok completed this in 76. Now, this has two important facets of this matter. His feigning ignorance about power attorney goes now because he had the document. He is the one who gave it to GRS. And at no point of time does he say this is fabricated, why did you do it? And revoking it or cancelling it, nothing like that was done. Then, my lord, at page 176, this is about when he came to know about the document being executed, the lease deed, about 4th line or so. Maybe around 77, 78, I visited Bangalore. JRS informed me about the registration of the lease deed. At that time, I told GRS that it was not as per our understanding. But looking at the building constructed by Ashok, I made inquiry with GRS. I came to know the lease deed is not as per our understanding. I inquired the terms of the lease deed. There, GRS has explained about the terms of the lease, and I have not written any letter to GRS or to Dr. Ashok repudiating the lease deed. Dr. Ashok may have paid an advance of rupees 50,000 to GRS as he has not paid any amount to me. I asked GRS about the advance paid under lease deed. Later on, I came to know about payment of advance. I asked GRS about the advance after registration of the lease deed, maybe around 78, 79. GRS told me about the amount of 25,000 paid by way of check. When I asked GRS about 25,000 rupees which he got by check, he said he had utilized it. I did not ask to pay that amount in writing expected really. About 79-80, I made the demand to pay 25,000 amount with GRS. GRS did not offer to pay me since he had utilized towards Reddy and Company. I did not make any specific demand with Ashok after I came to know about the lease deed because of due change of terms in the lease deed. Suit property was purchased by my father from the partner of a firm by name Shrikanteshwar Iyer. The name of the firm is Doreswamy Iyer and Company. Under some settlements, the firm, namely Doreswamy Iyer and Company, there the said Shrikanteshwar Iyer has got the property. To some extent, I took the help of GRS in forming the layout and all formalities connected with it. As I was in Madras, I am not giving financial difficulty in 74 or thereafter. I did not raise any loan from banks for construction. So, this makes the position clear that even though he purportedly came to know about this document in 77, after the 75 execution, he keeps quiet about it. Even though GRS tells him all these things, he doesn't do anything. The least that he could have done is, I never agreed for any such covenant. Why did you do it? Then there is some cross-examination not relating to signatures of JRS at page 184. The signature on exhibit P12, P12 was the rent receipt. He is confronted to witness. He opined that the signature may be the signature of GRS and also confirmed the signature as P11A and P15A. Witness opined that the said signatures may be signatures of GRS. So far, in respect of amount received at exhibit P11 to 15 is asked with GRS. For that, GRS has answered to me that he has utilized it. So, not this completely seals their case, is my respectful submission. He says GRS received it. GRS has a power of attorney, and if the agent has not given the money to his principal, that doesn't mean that the principal, the payer doesn't get a discharge. And he says, I didn't ask him. And what did you and me asked him? He said, I used it. And they had all these other transactions intersect. Then I never received a draft sale deed. And then one sentence. I did not ask GRS, and the same does not arise since the said documents are created in the hands of GRS and Dr. Ashok in collusion. Now, what is the collusion? When was the collusion? And why does he say it is collusion? Nothing. I never received a draft sale deed from Ashok. Ashok did not tell me about sending him the draft sale deed. In October, November, I came to know that Ashok was getting prepared to the draft sale deed on his own. On a visit to Bangalore for a function, Dr. Ashok mentioned to me that he is getting prepared draft sale deed on his own. That function, small get-together, which has in his wife's flat in Bangalore, in finite homes occasions, is on account of new construction of the flat. In the said get-together, the relatives of my wife and Ramchandra Murthy, V. Shivanath, so-and-so, were coaxed with the said function. Income tax clearance is not required for sale of property during 73. And from 1948, I've been an income tax assessee. I've been filing returns regularly. In 83, 84, assessments are passed on payment made by me. No appeal has been preferred against NTS. No demand has been made. Then at page 186, he refers to his marriage. And then P31, your lordship saw, is that the legal notice and reply. He says he only gave instructions for that. At the bottom, of page 186. Then two more questions at page 191. Exhibit P30 and P31. He denies that he has written that, not the middle. It is false to suggest I made a statement at P31 and I signed the said P31. I am not aware of P30 and I have not written P30A. It is false to suggest that I made a statement at P22 and I signed the document. It is false to suggest that I have given P33 and I signed the said document. False to suggest that I have given P35, I signed the said document. Then, there's a question about capital gains. The lordship saw the letter already. Question: did you ask Dr. Ashok to bear the capital gains from the sale of zoo property? I did not ask Dr. Ashok, and the said question does not arise. Ashok did not offer to bear the tax. I have been involved with any court proceedings during the 70s. It is false to suggest that Ashok always agreed to purchase food property. I got idea in early 70s itself to make sites and develop the property. It is false to suggest Dr. Ashok having interest in purchase food property. Not correct to say that I got this idea with a view to raise money, the view to meet requirement in Mumbai. Then, my lord, lease, what is the object of all that is gone through? And that concludes, my lord, the reading of the depositions of the parties. And what, my lord, in my submission would appear is that the witness is certainly, my lord, not somebody who is reliable, trustworthy, or truthful. All the three, my lord, are qualities which come out as the way in which there is prevarication. My lord, the stand about first 2 pages being inserted in the power of attorney that document, if your leadership could please see it again in the original, in the court file, every page, my lord, is sealed by the sub-registrar. There's a seal.
P29.
Yes, P29. And there is some signature on the top of that page, each page, first 2 pages. The stamp vendor may not have signed it. And there's a seal of the sub-registrar also. And the sub-registrar's endorsement is in handwriting. Power of attorney has been executed by so-and-so in my presence. His identity is proved by so-and-so. Signature of the person identifying the principal is taken. So if I had to do anything like this, then sub-registrar also have to be a party to the so-called fraud.
Just a moment, are you referring to P29?
P29.
Yes, there is.
That is the original of P29, my lord,
Original of P. Yes, yes.
in
What
the
does
trial
it
court
say?
record. In page 1, your lordships will get the date 26 September 1974.
Yes.
Yes.
There, my lord, stamp vendor is issued the thing. Three sheets are there, 2 sheets on stamp paper are there.
Yes.
The second page, your lordship sees there's a seal of the sub-registrar is there.
Yes.
Then third page also it is there.
Yes.
Then fourth page is the last page, my lord, endorsement page. In that also his seal is there.
Yes, yes.
He has endorsed
Yes.
this document executed in my presence. So, my lord, if you have to believe their version, that this pages 1 and 2, where he says my signature is not there, if that has to be believed, and if document is to be treated as something which is concocted, then it must be with the connivance of the sub-registrar also. That they take and get one document signed before him, and then they substitute some pages. And put some seal also.
Signature is not there in 1 and 2, it is there only in the 3rd page.
Yes,
That is true.
yes, ma'am. And the clause which they take exception to is in page 2, clause number 7.
There is this. 2, 3, I mean, 1, 2, 3. Signature is not there in 1 and 2. Seal is there in all pages.
Yes. And 77, he says he
One
saw.
more aspect to it. There is
Yes.
one more aspect. Receive the authentication fee of ₹3.
Yes,
This power contains one interlineation
at page 1.
number 1.
Correct. So that is, my lord, if your lordship sees first page, after 40 years, it's
is
written on
residing at
73
Vishnubag,
Yes.
so Andheri, Bombay.
That's the only
That is
change, addition.
recorded by the joint
Sub-registrar.
sub-registrar in the last page also.
Nowadays, in court affidavits also, my lord, if there's any correction in the affidavit, the notary or the authorized officer who's administering oath will have to write at the bottom number of corrections.
Correct.
And we'll have to initial or authenticate if it's 3 or 4 corrections. So, my lord, in the light of these facts, my submission, my lord, is that the trial court was not right. Lord, I have some propositions of law I will state, my lord, and then take your lordships through some case law whenever possible. Before that, my lord, if I may just state these propositions, my lord, and then take your lordships through the trial court order, so that my lord, probably we'll be able to appreciate his findings better, my lord. The first submission, my lord, is this, that a sale or a transfer, assuming this is joint family property, sale or transfer of a property by the Karta before the birth of his children and when there were no co-parceners, can that be challenged by somebody born subsequently when the property had ceased to be joint family property because of partition between the only two members of the family? But there is some doubt on the proposition whether there can be a HUF with only one male member.
Yes.
That is somewhat answered to say that it is possible that one male member will himself constitute a family, but then for other incidents of joint family, it should expand. That means he must either get married or he must beget children, married and beget children. So that is the first question, my lord, which may fall for consideration. Then the Karta's power of alienation. It's well settled, my lord, unless the co-parcener is able to attack that alienation on the ground that it is for fraudulent purpose or for immoral purpose, the action of the Karta, it cannot be questioned at all. Especially by those who are not alive on the date of that transaction. Then the trial court seems to think that an agreement come for lease with the sale covenant is not valid. My lord, I don't know why that view has found favor, because every day we are seeing all statutory authorities are executing lease cum sale agreement. This is a lease, you fulfill these conditions. After this time, you are entitled to sale deed. And that's covered, my lord, by high authority also. Now, if you want to plead fraud, you must specifically plead it. And you must specifically say who did the fraud, what was the fraud. Did sub-registrar do it? Who did it? And the documents are before the court. And at one breath, they admit that this document is signed by agent. In the same breath, they say that he received the money also. But now when it doesn't suit them, they say it is fraud. Fraud so far as receipts, fraud so far as power of attorney, fraud so far as the agreement, all the three. Now, at different points of time, in different contexts, they have admitted all the three. In judicial proceedings, he has admitted. In a registered partition between him and his wife, he has admitted that I'm going to, this property has to be sold.
Yes.
Then, my lord, 53A of the Transfer of Property Act, I've been put in possession. I have been in possession in part performance. I have complied with the terms. I've put up the house. And I am in undisturbed possession. And this is in furtherance to the covenant of sale. Though, my lord, I have a dual capacity. One capacity as a tenant, another capacity as an agreement holder for purchase. So I will be entitled to the benefit of 53A. The specific relief act, my lord, whatever requirements are there, I have complied with it. There is nothing that I have not complied with. On the question of minor, my lord, my submission is the minor has the capacity to be a party to a contract. So long as it benefits him, he can stand by it. Then, my lord, the document must be read as a whole. If we see the background in which the document was entered into, the relationship of the parties, the large extent of land which the family held, and the fact that they were, always thinking of turning to account, selling something, dividing it, giving it for development. This was nothing very extraordinary or something. I can understand, my lord, if the family had only one house, residential house, and the father enters into a silly agreement to sell it away to somebody. It is possible. Here it's not so. Then, my lord, to what extent oral evidence will assist them when there is a documentary evidence, section 92 of the Evidence Act, my lord, I'll cite one. Then agent's action, my lord, will always bind the principal. It's not possible for the principal to disown the agent. If at all he has any cause of action, he should proceed against the agent if he didn't give him the money. But may now take your lordship through the judgment. This is in the first volume, or paper book volume.
Yes.
Just from the judgment, my lord, is in volume 1 only. It begins, my lord, at page number 196. At page 206, the issues, my lord, are noticed.
Yes.
And 207, the issues in the companion suit. The first 4 issues, my lord, they relate to lease agreement, proof of consideration, and readiness and willingness, and specific performance. The discussion begins, my lord, at 209. There are stray observations, my lord, made by in the course of this consideration as to whether this agreement was really entered into. At page 213, third line, when there is no talk of sale in the year 73, or when there is no agreement of sale, page 213, the third line. The court seems to think that there should be a separate agreement for lease and separate agreement for sale. Page 213. So when there is no talk of sale in the year 1973, or when there is no agreement of sale, certainly Exhibit P1 cannot be considered as an agreement of sale. It is true that Sheshadri, who is the power attorney holder, the defendant, has executed the lease deed on 6 February 75 at P1. But according to me, is based on talks that took place between defendants and plaintiffs here in the year November 73, and nowhere it is recited that fresh talks took place between plaintiff and defendant after November 73. Plaintiffs have already relied on P29, which is a power attorney executed by defendant in favor of Sheshadri to collect the income and to pay taxes and to lease the scheduled property and to negotiate and fix price for selling scheduled property. It is dated 9/12/74. So here, though P29 is a document of defendants, even then it is produced and relied upon by the plaintiff to establish their claim. I don't know, it's somewhat difficult to understand. Power attorney is given, that document is given to the purchaser, the agent signs the document, therefore I will have to ask for his document. Court says, why is the document with me? It should be with the agent. But here, admittedly, according to plaintiff, the lease talks took place in the year 73 with defendants herein. Subsequently, lease deed had been executed by the power attorney holder of defendants by name Sheshadri in the year 75. In the year 74 itself, before executing P1, Sheshadri, the lease talks took place between plaintiffs and defendant in respect to suitable property in the year 73. If that is so, there was no hurdle for plaintiff to incorporate such terms alleged to have been taken place between defendants and plaintiffs in the year 73, November, in P29. So it is clear that sale talks were not at all took place between plaintiffs and defendant or between plaintiff and Sheshadri on the date of P1. Now, there's a great deal of confusion in the mind of the learned judge. whether there was talks, when the talks were held and the relationship of the parties, that shows, and rightly or wrongly, there is a document that has come into being. And 74 power attorney is executed for this purpose of enabling him. And his evidence is, I asked my cousin to look after all my affairs in Bangalore. Then, my lord, again at the bottom of 214. However, till 75, J.R. CH-3 will not come into picture. But in the year 74, December 9th, power of attorney was executed with the defendant in favor of CH-3, and from December 74 onward, J.R. CH-3 became power of attorney holder of defendant in respect to suit property. Therefore, for the first time, J.R. CH-3 has inserted the clause in P1 in 95. That option has been reserved in favor of the plaintiff to purchase the suit scheduled property for 1 lakh. I think this must be a mistake, my lord. It should be 75. Looks like a typographical error. Then in the middle of that page, my lord, the learned judge seems to think that you must have a separate agreement. However, even though if we come to the conclusion that J.R. CH-3 was authorized to sell the suit scheduled property to plaintiffs herein, even then, admittedly, there is no separate agreement of sale between CH-3 and plaintiffs, except P1. If so, we have to consider that whether the option reserved in favor of plaintiffs to purchase suit property as existing in P1 is sufficient to constitute the provision of 53A and 54 of the Transfer of Property Act been complied. Then, my lord, very strangely at page 216, after the extract, the judge comes to a conclusion. There is no nexus between P1 and the contract entered into. P1 itself is a contract.
Is the finding that the covenant in Exhibit P1 is inserted at a later stage by the power of attorney? Is that the...
No, that's not their stand. Their stand only.
Is that how it has been understood by the court?
No,
Just wondering.
the judge, my lord, seems to think that you cannot have one document which says lease and coupled with an agreement. And for that, he goes back to say, what was the understanding? What was the discussion that took place? And this agent comes in 74 and signs an agreement in 75.
Inserted. It appears that that is the finding. Just a moment. Agreement P1 is a deed of indenture, lease in respect of suit scheduled property. Even it is admitted that P1 is lease deed. At the outset time of the opinion, P1 is not an agreement for sale. Yes, that is the finding. But it cannot be a composite document is the finding.
Yes.
That if P1 is a lease, it has to be lease simpliciter, nothing further.
Yes, that's what the learned judge, my lord, is, I think, expressing the view.
Yes.
Then, my lord, at the bottom of page 216, we get the same kind of impression.
Yes.
After that extract, my lord, considering the above decision, it is clear that there is no real nexus between P1 and the contract entered into between the parties, and hence the provisions under 53A of the TPA Act not complied, because as per P1, real contract entered into between the parties is for leasing the suit scheduled property in favor of plaintiffs and not for agreement of sale. So the nomenclature of the document is what the judge thinks is wrong. Therefore, in view of the above decision, we cannot consider P1 as an agreement of sale.
We cannot consider that P1 is not an agreement.
Yes.
The double negative.
Yes. We cannot consider that P1 is not an agreement of sale, he says. So I think that not is, I think, not correct in the sense. That's not what the judge meant to say.
Yes.
Then not at page 218, bottom, he now goes as to why CH-3 signed such a document. Where is the need for him to sign such a document? About 8 or 9 lines from the bottom, Lord. Nowhere it is recited in P1 that J.R. Sheshadri had offered to sell the suit scheduled property and accordingly plaintiff have accepted the same. Further admitted that there was no occasion for Sheshadri for agreeing to sell the suit property to plaintiffs. Looking to P1, nowhere it is contended that family of the defendant was under legal necessity or financial difficulties. There was no family then. And therefore, for that reason, J.R. Sheshadri, power attorney holder of plaintiff, had undertaken to sell the suit property in favor of plaintiffs. So considering P1 absolutely, there is no reason for J.R. Sheshadri to sell the scheduled property in favor of plaintiffs. Even if it is not the case of plaintiff that family of the defendant was in legal necessity or in financial difficulty, therefore it was a reason for defendants or J.R. Sheshadri to sell the suit property in favor of the plaintiffs herein. And no agreement, etc. He concludes on this point at page 220, last one line at the bottom of that page, just above para 7.03. Therefore, for this reason also, it cannot be considered or cannot construed that P1 is an agreement of sale. Then he goes to the consideration at page 221. The documents are referred to. At 222, he notices payment of 50,000 and balance was to be paid. Then notices the receipts. The reason why my payment is disbelieved, your lordships will get at page 224, middle of that page. Therefore, again, there is variation in the plain pleadings in para 3.5 and exhibit P16 with regard to the passing of consideration amount. It is true that it is mentioned in P16 that the defendant has received again different amounts by cash and check by different dates. Accordingly, it is recited in P16 that 1 lakh has been paid by plaintiffs. There is recited in para 5 of the plaint that an amount of 1 lakh has been paid to defendant as on the date of sale agreement and not on different dates as mentioned in P16. Therefore, certainly the payment mentioned in different dates itself at P16 cannot be considered. However, there is no dispute on perusal of P27 reply issued by counsel for defendant to the counsel for plaintiffs. The defendant has received 50,000 out of 1 lakh. So the dispute is in respect of remaining 50,000. That aspect of the matter is not ready to admit by defendant. In this regard, perusal of P26 legal notice, it is stated that further amount of 50,000 is also paid, but the said notice, which is dated 9/1/1996, nowhere it is stated further amount of 50,000 was paid. Of course, he is denying it. So I produced proof, show what are the details of the payments. I produced bank accounts. I produced bank statements. I produced receipts issued by them. And the conclusions at 227, about 7 or 8 lines. Therefore, in view of these variations in the pleadings and the proof, inconsistent stand taken by plaintiff cannot give much importance to this P60.
Yes.
Then, my lord, page 229, he comments about this power of attorney and says that who had to receive the money. The document is very clear, about 4 or 5 lines from the top, my lord. If so, certainly defendant is not a proper person to accept these payments. Even plaintiffs cannot make these payments directly to defendant. Because when general power of attorney executed in favor of Sheshadri is still in force, certainly whatever the transaction took place subsequent to P1 are also must be between plaintiffs and Sheshadri. Therefore, there is no occasion for defendant to execute receipt P16 that he has received payment of 1 lakh on different dates. Admittedly, according to plaintiff, 25,000, another 25,000 noted in P1 has been received by Sheshadri. Here, Sheshadri is not a party to the proceedings. Even it is not the case that the entire side, the J.R. Sheshadri as necessary party, will not come in evidence that Sheshadri is not alive. However, even though if you have to come to conclusion Sheshadri is alive, no difficulty for every receipt of payment made by him to Sheshadri. It's already CH received payment as part attorney holder. CH-3 is a competent person to give reply to this case. But it's like saying it's not an assignment of a debt. I'm appointing somebody as an agent to do something. Does it mean that the principal cannot receive the money? Money is received by the grantor of the power attorney. The learned judge seems to think the minute you appointed CH-3, it's like an assignment of a debt. If a debt is absolutely assigned to the ARCs that they now do, then the bank can't receive it, only ARC has to receive it. So to that extent, my lord, there is a complete misdirection, is my respectful submission. Then there's a lot of discussion to say that this payment is not duly proved. But the same thing is not is going about in a circular fashion. Though judgment is very lengthy, but then most of the discussion is centering around this only. Then chartered accountants also not there. Kindly turn to page 251. May I take another few minutes, Manoj, or continue?
No, judgments also, anyway, we have to.
Yes, yes. I'll not take another 5-10 minutes at the most, and then I'll quickly take a lordship through judgments. I made a compilation also. Please, ma'am.
Can we
Please.
continue tomorrow?
Yes, yes, please, ma'am. Yes.
Content is not available?
No, it's online.
appeared in the mode.
They've logged in.
Yes. Where is it? Speed of this one.
Your Lordship, serial number 40 also similar situation.
Yes.
A short date, I think tomorrow, can it be taken up?
Let's,
40.
let us see. Please, the dates, we don't know what other matters are listed. Please, we'll see. The earliest dates will be.
Good afternoon, sir. Good afternoon, sir.
Put up, sir. Put up, sir. Put up, ಇಲ್ವಲ್ಲೇ?
ಹೇಳಿ ಸರ್ ಅಡಗ್ಲಿ ಅವರೇ.
ಮೇಡಮ್ ರೀಚ್ ಆಗಿದ್ರೆ ಮ್ಯಾಟ್ರ್ ಯಾವತ್ತು ಆಗ್ತೀರಿ ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 49.
49.
ಹೌದು ಮೇಡಮ್.
49 3-2 ಸರ್ 3rd of February.
ಸರಿ ಮೇಡಮ್, ಓಕೆ ಮೇಡಮ್.
ಓಕೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.